Give it. I'm
Yesterday in the evening, so I
I'm
couldn't
keeping
get it.
at 2 p.m. You come with something in writing. You
Lordship.
put a mail, whatever you have. I'll keep it on record. Record that, and things will be over. Because in any case, it's a small amount. If you can settle
Exactly,
it,
Milord.
That is why we were trying to
only that
use our
COVID
offices to the best
situation,
of
Milord,
possible extent.
you are interested in the money. You are
Yes.
getting the money. So unnecessarily, why would you sell somebody's property if
But
Milord, it's
the point
entirely that COVID scenario which
sale-
topsy-turvy
is there a
thing.
sale which is up and coming? No.
Milord, today is the
Today.
date,
For
Milord, for auction. But Milord, the bank has also informed my client
There is
that
no
there is no bid as of now. Milord, but I don't know because it's not on record. It's all verbal, which is. But since we both are in there, Milord, both from us feeling that bank is agreeable to settle the issue.
if bank can settle it, settle it.
No.
Should I keep it at 12? You get a mail. I'm keeping it
12,
at
because for safety of my advocate on record and everything,
Yes.
Milord, we need to have
That
it in writing.
Which is why I said, which is why even if the advocate on record mentions for withdrawal, I make it a point that I keep it.
Yes,
because It is for your safety. My order will be immune from whatever you say
Yes, yes.
because there is a presumption as regards correctness of judicial records. And I will not record something which you have not submitted
My
because
lord.
there is always another side.
Yes.
So therefore, for your safety, you put something on record that makes things concrete.
My lord. I'll keep it at 12.
Keeping at 12,
12
And the
Come
total
back,
amount due is
take a
not
mail.
15 lakh, it's 27.
No, it's settlement.
mail something in
Total
writing
figure
which
of
is
that.
addressed to him as well as your advocate on record.
My lord.
Both the parties should be in the know of whatever it is. Then that will make things easier. If both parties are agreeing to settle, I cannot.
Exactly, Milord, amount is so meager. Milord, if he given a chance, Milord, he can pay because now his business has resumed.
Employ your good offices and see if you can
Yes.
settle it. Yes, next.
I am for the state.
Item
But
number
item
20 for the petition number.
Lordship, item 2. But I am told that Mr. Nayak is appearing for the WBSCDCL. Milord. But he is
Not
yet
there.
to reach High Court. He is on his way. Short password I am paying on his behalf.
Passed over. Password করে কি করব? Jam time আছে আজকে।
My lord, item number 3 and 4, I praying for short Passover.
Okay. Why you are there, you do it.
My lord, my senior is on the way, my lord.
Why is Mr. Haldar so late in court? It's 10:37.
Lordship, then can you keep it for tomorrow if it is not today then?
Not today.
Because I'm grateful.
The condition is very bad out.
Short Passover, my lord.
I beg to appear for the
Passover.
ombudsman. Then not. Make it not today, Lordship.
Not today.
So much.
Item number 5, I have been instructed to appear on behalf of the respondent number 6, my lord.
Please, your lordship, millet.
State.
And I have
For
not
the
received-
petitioner, millet, for the petitioner bank, millet.
and I have
Millet, the application is pending, millet. The order has been passed. Millet,
Ah.
till now, millet, the police has not, or the DM, millet, has not taken any steps to take physical possession.
Lordship, the police has already asked them to identify
Hearing for the state.
state, your lordship.
I'm praying
Police
for
has already intimated them through a letter to identify the assets for which they need the police assistance. But the bank
We have already identified, millet. Millet, yesterday, millet, what they have given, they have identified, millet, and they had provided us with the police cost after receiving this writ petition, millet. Millet, what I am humbly praying before your lordship, millet, that a time period be,
Have you put in the police costs?
millet, yesterday we received the police cost
Very
quotation.
well, once he puts in the police costs, you,
I have-
and identifies the
I have
No,
giving police protection for the
Not
purpose
very-
of
no.
yes,
I have not received any copy of the writ petition. Kindly fix.
required. You are a borrower.
I'm
You
the
don't
borrower.
have any right of audience also. He has made you a party. All you be satisfied with that. Section 14 order, the DM has, it's only for implementation. If you are aggrieved, challenge it before the DA. What can you submit here?
My lordship, in this matter, I'm for the state. My lordship, I'll be praying for a 1 week adjournment. My lordship, the instruction is not yet
My
came.
lord, disposal of section 14 application, it's still pending. My lord. It's pending.
Disposal is pending. and
Disposal is-
ask him to dispose it off.
No.
May
I am
please
for the
lordship.
state respondent.
Sir.
Huh?
Eta आम्ही petitioner आहे.
Yes.
I am for the state respondent.
Millet CGM order passed, millet no steps, millet like. Millet yesterday in this matter, millet we received the letter for police cost.
But deposited the police.
Millet yesterday we received, millet.
Very well, then once he deposits you, this application, this writ petition seeks expeditious disposal.
That I appear on behalf of the.
My lord, due to 15 August, it is totally, we could not reach in time. My lord, the petitioner is there.
This is item 8.
Yes, item.
Yes.
My lord, 83 years old woman and getting electricity more than 30 years. All of a sudden they came disconnected my life without any notice, without any outstanding dues. Thereafter, they have not sent me
Yes, Mr. Mukherjee,
connection
why have you
notice or
disconnected?
provisional order of assessment, nothing has been sent.
Disconnected on the ground of pilferage, my lord.
But
that
we have
the
not
final-
served anything on her.
My lord, she has come and signed, my lord. This is the. Acceptance.
Acceptance of. What's going on?
And the final order has been passed in the month of July 8th. To the tune of 1,27,000 something, my lord.
देखिए दिन होना
1,27,102, my lord.
হিয়ারিং এ তো অ্যাপিয়ার করেছে ইনস্ট্রাকশন নেওয়ার জন্য টাইম
Let it be tomorrow. I'll take it. sir.
not
আরে তুমি
today.
এখন দিলে আমি কি করে জানবো?
আপনার মক্কেল দেয়নি আমি কি করবো?
আমি কি করে জানবো? এটা কি মক্কেলকে তুমি
না না দেয় না
তুমি রিসিভ করে নিতে কোনো কপি দিয়েছো?
ও আচ্ছা। তারা এতদিন বলছিলেন রিসিট কিছু জানে না, এখন রিসিট করলে কপি
Well, let it be tomorrow.
Taken in as prayed for by Mr. Haldar. Please.
Item number 9, my lord, I have got instruction to appear on behalf of WBSCDCL. I have just received it today, my lord. I'll keep it on Monday, my lord.
Monday. But the same issue, subsequent purchaser has been saddled with the dues of the erstwhile consumer. Only difference is the disconnection had taken place in the year 2014. After 12 years, my lord, this is if charge is also there, that is also barred by limitation as on today. There's a 12-year limitation period. That is also barred. My lord can fix the matter on 31st because same issue. But my lord has already fixed.
My lord, I have to
Meantime,
take
then
instruction of
they
Mr.
may file their
Chakraborty in the
affidavits.
other side, my lord.
Then they may file their affidavits in the meantime.
I was saying that, my lord,
Yes.
let us 31st, my lord has already fixed the
Taken in.
matter.
And on the same issue, it will be heard. Full stop.
That my limited challenge, the action of the police authorities in transgressing the order of the CJM, Chief Judicial Magistrate, in under Section 14 of the Service Act. The original petition is pending with the tribunal, but immediate question is
going to the tribunal only. Why here?
I'm coming. But first of all, the DRT3 is not functioning, but
So
here,
what? Somebody
here
must
the
be in
natural
charge.
justice is violated. Kindly just permit me just to play two paragraphs. Kindly comes to the Section 14 order. Just one page at page 43. The CGM is giving the direction to the court belief that at least to give 7 days prior notice before taking of the possession. 13.4 is over. That kindly comes to page 43. That after the schedule of the property number 1, that the appointed commissioner shall give possession notice to the authorized officer of the secretary and the borrowers to be served personally speed post at least 7 days in advance. Copy
Where
of
is that? Where are you reading?
that page 43,
Yes.
just below middle, after the schedule of the property. Property number 1 has your lordship got it. Schedule
Yes.
of the property. Just thereafter, the paragraph starting from appointed commissioner. Appointed commissioner, as your lordship got it, shall give at least 7 days prior notice to the borrower. As your lordship got it. Thus, this paragraph. And copy of 7 days advance notice shall also be affixed on such and such. That
Yes.
That kindly comes to then page 41. Just prior to that, page 41, this is a possession notice of the bailiff. It is dated 3rd of August 2026, served upon us on 5th of August. Now, lordship kindly comes to, just for once,
Where do
kindly
I
comes
get that it was served upon you on 5th of August?
5th of August. I have stated
From where do
in
I
the
get that?
paragraph, in the statement that I have made that amendment. That I have stated that at paragraph 11, at page 11, I'm sorry, page 11, sir, it is pertinent to mention that as part of the said order dated, it has been communicated by this court belief to the petitioners through speed post on 5th of August. Now, my kindly comes to just once. But your lordship is surprised to see how the police authorities is not acting this type of order. Page 48, kindly comes to page 48, just for once, page 48. This is not the notice. Your lordship will find it at the bottom, dated 6th of August 2026. Just bottom. So notice dated 6th of August 2026 served upon us on that day itself. We are admitting that. Kindly see what he is stating. This is to inform that in connection with above or reference, Additional Chief Judicial Magistrate Adipur has been passed an order such and such. With reference to this is to inform that I have been appointed as court commissioner. There is no such order that police authorities have been appointed court commissioner. Then he is asking,
Lord,
he is asking,
but I'm very
to get
sorry.
the property kindly.
I'm very sorry. He has quoted that notice, blood.
Let him continue.
They have failed to
Then
understand that.
kindly come to this, blood.
They have
Then
failed to
thereafter,
understand.
we are requested to vacate the property on 10th of August. So 7 days prior notice is not given. So
41 has been quoted.
6th of August, this order, we are directed to vacate on 10th, and the prior notice, basic notice, 5th of August, we have received 3rd date. So that 7 days notice is not complied with as per the CGM's orders under section 14. My limited question is only this notice. I should be given some time, not if the bank authorities exceed, I will set. I am ready to settle the dispute within 1 month.
No question of settling. At best, they will instead of 11th, if they go on 13th, 7 days will be complied with.
7 days,
If that is your only grievance.
No, that is not only because I am only submitting it subject to what they say. I am ready to pay some amount right on.
Nothing on
I'll settle the
nothing
dispute.
on
Action
merit, sir.
notice has not.
Lord, I was appearing for the state only to say, Lord, this is the petitioner's, Lord, he has misunderstood the entire thing. If my Lord sees page 41, kindly see the entire notice starting from with reference to 410 has been copied in the notice of the police authorities. He has said that this is to inform you, magistrate has passed this order. And the last paragraph is the information given by the police. Accordingly, you are requested to cooperate. So, Lord, completely misnomer. He has completely on a misunderstanding. He has filed the petition.
When are you going to take possession?
But whenever the bank says he's for the bank, we have got nothing to do.
Why
There is an
did
order.
you go on 13th? His remedy will go.
His predicament entire, if you go by the entire facts of the petition, default, mortgage, everything has been admitted.
No, that is
not
I'm not going.
I'm submitting even that.
Mr.
So far as 7 days notice is concerned, Lordship, the notice itself is saying on 11 or so soon thereafter.
No, no,
Tomorrow
10,
from
honor,
instruction and
10.
submitting from the bank. Your Lordship, is that till today police cost has not yet been deposited.
Then
So this
after
withdrawal is
13th it
not
will
But
go.
I'm only praying,
Nothing.
your Lordship, if the
No,
bank.
May I take a lordship?
Nothing more than
Only
that.
the
May I take my
object
lord?
is not the payment is made.
But if one can make your payment, you say settle it with the bank, but there is no reason
So
to
that
contradict
liberty
this.
I should
The
observe that.
bank says that he has not paid the police cost. Once they are paid, in the meantime, your 7 days will expire.
Kindly observe that,
The writ petition,
the liberty to, to take
the
it as
writ
for settled.
petition alleges arbitrariness
Yesterday.
हाँ,
They are here. But I can give them a copy of the writ petition here and now. Now, the facts are, kindly takes up page 124 of the writ petition once. But I am aggrieved by this notice under section 14, by which they intend to take possession on 11th or 12th of August, which is today or tomorrow. This notice is as against dead persons. Now, Ananda Ghosh is the borrower. 3, he is dead.
When the notice under section 13(2) was issued, the
2000,
persons were alive or not?
2009, Ananda was dead at that time.
When was the notice under section 13(2) issued?
14th of January 2009.
And when did he die?
He died prior to that in 2008.
No, then why did you allow the proceedings?
No, I am not Anando. We are the legal heirs of the guarantor Mir Mohammad Yusuf. Now, Mir Mohammad Yusuf died on 20th of January 2025.
Very
Now,
well,
if
then
your
if the
lordship,
20th, if he died in 25, then in
Lordship.
that case, what is wrong with that?
now, the notice is against Mir Mohammad Yusuf, a dead person.
Very well. So the proceedings were initiated long back.
Now, kindly comes to bank had knowledge that Mir Mohammad Yusuf has died. If your lordship,
Take
takes
this matter before the DRT. This is not such a matter where High Court
now,
should intervene.
tomorrow they will be taking possession.
Tomorrow, Millet, as far as my learned friend's apprehension is concerned, till now, police cost has not been paid, Millet.
You have
And Millet,
Let them record that, kindly grants me some breathing space.
no breathing
so
space
that I
to be
can
granted.
approach
You
the
approach
DRT.
you approach the DRT, no breathing space. You are aware of the recent Supreme Court judgments. No breathing space can be granted if you have an alternative remedy. If I am not entertaining the writ petition, no
Lordship
breathing
would then record, the
Yes,
submissions.
I record that he has not paid police costs as yet.
till now, Millet, we haven't received, Millet, any intimation from the
Any
police.
intimation from the office.
Millet.
The petitioner is aggrieved.
I appear for CSC, my lord. Even the last occasion, none appeared for the petitioner, my lord. They are not interested, probably. Outstanding
Yes.
views, my lord.
None appears for the petitioner. No cost. How can
On 13, I am for the petitioner. Petition made.
Although this matter has been appeared as some other purpose, but when he is appearing, I have to bring the inspection report because there is a earlier direction that an inspection has to be caused because he applied for electric connection. Our instruction was that where the petitioner is in occupation, he could not locate the same. That's why the direction has been passed to make an inspection. We have made the inspection, truly speaking, in view of the last order, further instruction has not been taken. Therefore, kindly give me 10 days time. I will.
No, 14 is the
same order?
Same 14, 15 same.
তুমি সঙ্গে ভালো
16 is
Same
No,
order.
16 আমার না। 16 আমার না।
লিখে নিন, আপনি লিখে নিন। ঠিক আছে। Mr. Mukherjee, learned advocate. Same order.
For the petition.
Mr. Mukherjee, what he has submitted, my lord, I have the same facts, my lord. There is an order passed on 6th of July 25, directing
10th of June 25.
10th of June 25, directing us to.
So none of the 10 June orders have been complied with.
Madam, will kindly give us time to inspect and find out.
ওই সেম অর্ডার কপি করে দিন, সেম অর্ডার।
ইনস্পেকশন হয়নি এটা
Inspection has been done.
Madam,
As per my instruction-
direct us for inspection, madam. It is freshly inspected.
Yes, my lord. Fresh inspection.
Same order হচ্ছে না, কেটে দিন। Mr. Mukherjee, learned advocate appearing for the petitioner submits that
17, 18, same one. Same as 13, 14, 15.
17, 18, 13, 14, 15 এর মতন করে দিন।
Grateful errors.
17, 18 same order as 13, 14.
Next.
এইটিন হয়ে গেছে।
17,
18 তো হয়ে গেল 19 এটাই মনে হয় 19 Well, 19, I am for the petitioner lordship.
I'm for the
My lord,
WBSS.
this is a matter relating to new electricity connection of submersible pump, my lord. Petitioner applied new electricity connection on submersible pump, my lord. Kindly see page 10. The application dated 20th August 2024, but till now, no.
Yes, why have you not?
Lordship, actually, we had inspected the premises, Lordship. However, on inspection, we found that there was a meter room which is missing. So we had intimated the petitioner to that aspect. Lordship, if the meter room is constructed, Lordship, we'll effect the connection within a reasonable
At
period
least
of
they
time.
issued quotation, my lord. In the meantime, I am complete.
My lord, if the meter
I
room is-
undertaken,
বলুন না।
I undertake, my lord.
My lord, if the meter
If
room
they
is
construct
completed,
the meter room, there's no other problem.
there is no other problem. If there is no valid problem, Lordship, we shall effect connection. Because once the meter room is constructed, Lordship, we'll,
In the meantime,
Can you provide relief also? I will provide for that.
Lordship,
yes, sir.
Lordship, this is my instruction, Lordship.
লিখে নিন। The petitioner, the affidavit of service,
ANSM so that
He's right.
certifying
The
completion.
petitioner shall inform the WBSCDCL authorities upon
Tomorrow?
not this week করে দিন. You serve copies. I'm making it not this week.
Mine.
Next.
Start করবে. My lord, your lordship kindly give the pass the order.
Same thing. Unnecessarily. Why for not this week? What order? Chalo, next call.
I'm just praying for a short passover.
You have not yet given the copies. What will be the use of praying short parts over? You have not yet given. In any case, it will be adjourned.
What is the big volume?
Yes.
চলুন call করুন.
Short Passover matter was there, item 2, Lordship.
Passover after 12, not now.
Our Lordship.
Not according to whenever somebody comes.
Well, in this, my lord, there is a mistake done by me. Well, we were supposed to put in the affidavit when it is ready, but the person concerned, his mother is not well. My lord, kindly give me time to tomorrow. I will affirm and give them a copy.
I will
Today.
be filing the reply to that affidavit.
Let the affidavit in opposition come first. Only then you will file the
Well,
reply.
keep it next week, my lord, with the
This
reply.
week. Next.
My lord, I appear on, my lord, on behalf of WBSCDCL, on the last occasion, I have filed a report.
Last one. You know, the report has come. You know, 3/26 order. Exception. No,
What is the matter about?
I just indicate to your lordship. Milord, this is with regard to a new connection. Milord, I say that, Milord, for the purpose of, Milord, giving this new connection to my neighbor, Milord, our electric pole, Milord, my learned friend's client is, Milord, proposing to install on a plot of land which, Milord, belongs to me. Milord, I say that I am not, Milord, opposing, Milord, this. I cannot, and I am not also, Milord, opposing the new connection. I only say, Milord, if an alternative route, Milord, can be obtained. Milord, to my understanding, to my client's understanding, there is, Milord, an alternative way where, Milord, a pole can be installed and without, Milord, disturbing my plot, Milord, connection can be given. Milord, there were, Milord, previous rounds of litigations, Milord, orders were passed. In some orders, Milord, some submissions were put, Milord, into my mouth. Milord, I do not want to get into that. Now, Milord, a report has come. Milord, I should have, Milord, checked the report. Milord, the report has reached me just now. Milord, may I just go through the report?
Well, we have served it on the last occasion.
Nobody is disputing that, Milord. It reached me, Milord, a few minutes back. And in the event, Milord, an exception is required, kindly allow me, Milord, 10 days time. Milord, I'll come back with an exception. I'll just come back with an exception.
As per by,
Mr. Mukherjee, if there is a dispute as regards way, why did you not approach the district magistrate?
There is an order of district collector joint inspection
Which
done.
is, Milord, under?
My lord, that has been challenged.
Which is under?
Where they have participated. Kindly come to page 42.
I did no wrong by participating.
No, I have not said that. Kindly come to page 42, my lord, the last portion. Hence, considering the joint
It
inspection.
says to draw electric connection through Panchayat Road.
That is the Panchayat road. He is claiming to be his place.
Old land.
That is the difficulty.
May I now show
And
the,
my lord, in my
Decide this, Mr. Banerjee.
may I now show, no. May I now show the difficulty, Milord? Kindly, Milord, take page 36 once. Kindly read this, Milord, side by side. Milord, page 42. Kindly, Milord, turn to page 36 once.
Yes.
Third paragraph.
second line, the plot number is given.
What paragraph?
Plot number, second line, plot
Is
number is,
501.
yes. Now kindly turn to page 42.
Page?
42, which is under challenge today.
Yes.
Clause Roman 1, second line. It's possibly them who are indicating different lines at different points of time. 36, they were indicating 501. 47, 42, they are indicating 502. I'm again saying, I do not want my neighbor to be there without electricity. That's not my intention at all. But if there is an alternative way, then that can be explored at least.
We have inspected. Page 36 is your submission that it is your land.
Correct. And it is on that land that the electric pole is going to be installed. 501 belongs to me.
So, but till such time that this is decided, the person cannot be without.
But I can come back in 3 days. Monday, chole asho. But I'll come back on Monday.
501.
Oh, he is. There is
501,
electricity.
my learned senior friend.
There is an alternative way. He has been given electricity subject to what my learned friend says.
Yes,
He is
Mr.
enjoying
Mukherjee,
electricity. He is enjoying electricity. That's what my specific instruction is.
You are enjoying electricity. He is not.
There is no instruction to that. But the only thing, I should not, in respect of the plot of land, I should not comment, but it is the petitioner said that the plot number 501 is there.
Correct.
And when I kindly come to page 42, which he has shown, that it is said that during inspection, it is found that the Panchayat road, as claimed by the local people, has gone through plot number 502. We want to install it in
502.
Yeah, title
502. If that be so, I may not be having any objection.
Kindly see.
502 is written there.
Yes.
Kindly allow me to come back on Friday.
And my lord, we have.
That's why I said that
On
your
Friday.
submission was 501. It is 502 there.
Possibly what is happening is, I have to go through the report. They are saying 502, but doing it practically on 501. I'll just check and come back. I'll just check and come back. This is the disparity, which is why this
There is no disparity.
There is no disparity.
There is.
501, 502 are different. How can there be disparity? Your submission was 501.
Correct.
District magistrate directed it to go through 502.
Correct. Kindly take 36 once more.
Yes.
Last 3 lines of the last third paragraph.
Yes.
WBSCDCL, but as the connection as well as the proposed pole will be erected over her land. He raised objection for the same. That's my submission.
Respect of 501.
Correct.
So it is not 501 anymore.
I just need to check that.
42 minor on the later part, it is categorically stated we want to install on the Panchayat road, and Panchayat road has been classified as plot number 502 as a Pukur and as well error map, and some houses are found located both sides.
What makes you challenge the district magistrate's order then? Because your challenge is confined to the district magistrate's order. What is the illegality here then?
Clause 3 is the illegality.
Clause 3 is no illegality.
During inspection, the petitioner and her family members unanimously agreed to release 3 feet. This is something which has been put into my mouth. May I ask this question to myself? Why should I?
Then Mr. Banerjee,
I should go back to the district magistrate for it.
Yes. How will the writ court say that this is wrong recording?
Kindly grant me that liberty. I'll exhaust that and come back.
They cannot be without electricity.
I've told they are. May I come back tomorrow?
No, I am not enjoying any.
2 years, they are without electricity is possibly something difficult to digest.
Every day, Mr. Banerjee, every day.
Every day, every second counts. 2 years without electricity.
When this device of district magistrate was in fact invented by the Honorable Supreme Court, reading section 67
Correct.
and works of licensees rule, the Honorable Supreme Court got into this aspect that even if the matter is pending, if you have a way out, give electricity.
I'm told they are having it. Can I come back tomorrow?
Come back.
Instruction. The report is absolutely silent on 501 and 502. A cursory look. A cursory look says.
Put it in the Panchayat road. We given a sketch map.
Eta Moja map jogar kar.
Because in any case, the writ court, how will I interfere with that order on that ground?
And my lord, I have to go back to district magistrate.
That can't be a ground.
If that my lord record,
Better.
yes, my lord, if the submission is wrongly recorded, my lord, I have to go back
the
to.
same authority who records it.
Absolutely.
Even if the authority is transferred, retired, whatever, he'll go back on the basis of the records and do it. It's a sort of a review.
No doubt.
May I kindly come to the sketch map. This is plot number 501. And this
Mr.
is
Banerjee, as a writ court, I'll be blind to all of that. It's a dispute of fact. Not today.
Well, day after tomorrow. Tomorrow I have some difficulty.
Day after tomorrow.
Helps being in.
Day after.
My learned friend wants an order.
Lot of orders have been there.
আমি চাইলে হতো না, তুই চাইলি।
you have got a killing smile.
As prayed for by
Passover. Lordship, give me a short Passover, please.
Then Lordship, kindly make it not today, Lordship.
today also you sought for a Passover.
He's engaged in another courtroom.
Every day he can't be engaged like this.
Lordship, kindly make it not today. Otherwise, Lordship can pass any direction regarding the filing.
Today, not today.
For the distribution company.
25, my lord, I am for the petition. On last occasion, your lordship direct report.
देखिए रिपोर्टটা দেখি
The private respondent has actually applied for an electric connection, and for that context, 3 number of poles has already been installed. He is obstructing to that connection.
Last occasion, my learned friend submitted that no application, no.
very well. Now he has submitted a report. So it is beyond 200 meters. It is beyond 200 meters. How will you stop?
No, my lord, that is not. My lord, then I have to take instruction and file, my lord.
Even in that context, my lord, I will present one small. It is only applicable to places which does not fall under the green zone.
Critical,
these are the
semi-critical.
critical and semi-critical list of.
This does not fall under semi-critical or.
This fall under the green zone.
Then I have to, my lord, file in the exception.
Because we have a report from the geological survey, and it doesn't.
A report filed on behalf of the respondent WBSCDCL authority.
my lord, I apologize, my lord, yesterday, my lord, I the report, my lord, the sketch map is not there with that report, your lordship kindly keeps it.
Well, I have perused the report, my lord, we are
My lord,
very agreeable to the report. They are inclined to draw the line over common passage.
Suggested the wayleave, lordship, we have
So
accepted.
now electricity
Yes.
can be
In
supplied.
terms of the inspection report, the connection be.
My lord, kindly peruse the report,
What
first
was the
page.
writ petition for?
Well, for
Restraining them from giving you supply.
We have never restrained, lordship,
They
because
restrain.
earlier, lordship,
They
they enjoy electricity connection from our own meter. So we are the,
You were obstructing in them
Yes,
getting
yes.
supply.
according to their lordship, is their allegation.
No, my lord, the WBCDCL
Kindly
started with
produce
this
the
that they are-
report, lordship, we suggested the route.
The petitioner has approached this court by way of the present writ petition, alleging inaction লিখে নিন।
Lord, I put the petition on the last occasion. There was a direction upon the licensee to file a report in the form of an affidavit, my lord.
May I hand over a copy of the
Copy.
Yes, you don't want to give or you want to give?
My lord, we cannot, madam. I kindly come to my report.
Very well, I'll come back in 5 minutes, then you show.
This is
My lord.
a new industrial connection.
But if I may submit, my lord, in para 5, the very reasoning that has been given is that no separate establishment has been found, my lord. Now, my lord, during inspection, my lord, they have found that industrial connection has been given to one Munshi Abdul Khair. But my lord, my contention is that I have a business license in my own name. Now we are a joint family, my lord. If my brother today has a separate business and he is enjoying industrial connection on the same self plot of land, my lord, can I be denied on the ground that I want to have a separate business which I am running since the year 2012, my lord, for the past 14 years, my lord? Just because I
will
want to
my
switch.
landed friend client take the responsibility in respect of any fire hazard and other
Lord,
things?
someone is already
There-
using one connection just
it is
because
a
I want a
dispute,
separate
family
establishment.
dispute,
No, my lord, absolutely not. My lord, my client is using that using that business using diesel, my lord. Now, since he wants to switch from diesel to electricity, my lord, suddenly there will be a fire hazard, my lord. That cannot be, my lord. That is not sustainable, my lord. I want to just simply switch from a diesel
There
connection.
is that averment that it is there will be a fire hazard.
My lord, kindly come to page 3, paragraph 5, my lord. We have not found a separate establishment. There is already 2 industrial connection there.
In the name of Munshi Abdul Khair, I am a separate
If
person.
there is no separate establishment, how can we provide in the same plot?
But how
my
could
lord?
there be two separate
That
industrial?
is already there, my lord. I kindly.
Could there be two separate industrial connections in the name of the same person then?
Malad, it separate connection, malad, in respect of 2, malad, kindly see 2 numbers are there.
In the name of the same person.
Maybe, but if it is in the name of the same person, merely because it is differentiated by 2 numbers, it won't make it different. It is catering
Malad,
to
that
the
is
same,
there, malad, which is there, malad.
to the same establishment in the name of the same person.
Yes.
If this was not risk fraud, how
Malad,
suddenly
probably at the time when the second one was given, malad, we have inspected and we have found it. We can take it is technically feasible. We have given. Malad, now, malad, it as far my landed friend has submitted, but it is the same plot of land. There is no separate establishment, malad.
Nobody it has been about
Malad,
fire hazard.
Malad, if it,
One person
malad,
can
it
get
is
2.
not
Why cannot
needed,
get
malad.
1? One person is enjoying 2
If he wants
connections.
to submit, malad, let him finish, then I will submit.
Wait for your turn. Yes.
But I have taken specific instruction on it. We have inspected, we have tried to find out a separate establishment, we have not. But if it is in the same plot of land, Manad, who will take the risk, Manad? Our technical experts are
Why
gone.
did he then give supply to the same person twice? So
Manad,
same
that-
person is getting 2 connections.
regarding regarding this, Manad, I can take
because of the
instruction
same
and come
person
back.
taking 2 connection,
Manad, absolutely, Manad, we just
had not been there in the name of this person, he would have got the connection.
Manad, we just fallen
Then
from
is
your
this not
lordship, Manad.
unjust?
Manad, I will take instruction regarding this and come back.
Then you file up a detailed affidavit.
As your lordship please, I
don't change your stand. You
No,
have
no,
not
no, no.
taken any
Which is
stand.
there, Manad. We have given 2 letters, Manad.
One thing I want to show, my lord. Page 6, my lord.
Page 6.
Page 6, my lord. The licensee himself states that I am the proprietor. Lotus Munshi is the petitioner, my lord. Therefore, my lord, it is established that I have a separate establishment. Otherwise,
There is
how
no
am I
separate-
proprietor?
We will clarify this.
Then why am I a proprietor, my lord?
No. Proprietor is in respect of a business. Proprietor
lord.
is not in respect of establishment.
My lord.
You may have a number of businesses in the same establishment.
My
You
lord.
may have a number of proprietors pertaining to the number of businesses run in the same establishment.
My lord, my lord.
Merely having a separate proprietorship would not ipso facto mean a separate premises also.
My lord.
In the same room, we can have 5 businesses.
My lord.
And 5 people may be proprietors of 5 different businesses, but that does not mean that the premises are also separate.
My lord, my lord.
That logic won't cut.
And my lord, in the pleadings, nowhere fire hazard has been stated, my
We
lord.
have not, because it is we have not found a separate establishment
So
that we have.
therefore, in your affidavit in opposition also, because I'll observe that should not be the reason here.
So we seek instruction, my lord. Bank is agreeable, we are also agreeable. The terms.
That
which we have-
helps.
That helps.
Yes, Mr. Chatterjee, agreeable, both parties are agreeable to this.
Only a minor, my lord, thing that is needs to be pointed out. We say that 3 lakhs to be paid today itself,
That is we are carrying.
and the rest, my
Paid,
lord.
no, not in
No, no,
court,
check
you
the
paid there.
check.
Payment,
3 lakh to be paid by cash deposit or RTGS, NEFT.
yes, it has to be RTGS or NEFT.
And the remaining, my lord, 11 lakhs 50,000 to be paid within 30th of September by way of one post-dated check.
My lord, cash, my lord, he has cash, but it is in home. So he has to go home, take the cash, go to the bank. Or, my lord, he was carrying a check of today's
Check
date.
they are not.
We do not have
agreeable,
instructions.
because
But
check will
then-
be subject to
Then, my
clearance.
lord, by going home, going back to bank will be working
He
hours.
should have been ready. See, everything can't be done through
No,
court
then, my lord, I
machinery.
will
If he's
arrange,
not
my lord.
ready, he has to do it somewhere.
No, that's
He has to do it.
And remaining amount, my lord, it's as by way of one post-dated check within 30th of September.
That is also, my lord, he was dividing it within 30th September by several checks or.
Very well,
amount?
I'll go by whatever the bank has said.
Very well. My lord, today, my lord, he is ready with 3 lakhs. He will.
Yes, he will pay whatever by whatever mode.
But my lord, bank with obviously, my lord, on consent of Mr. Chatterjee. My lord, since I will go back home and come back to the bank, let the working hours for me be extended for an hour. My lord, instead of closing me at 4:30, my lord, let it be at 6. By 6 o'clock, I will reach bank after going back home.
Why doesn't he call somebody from home and get it here?
কাউকে একটা ফোন করে বলুন যে টাকাটা দিচ্ছি।
উনি ব্যাংকে চলে যান, ও টাকাটা নিয়ে ব্যাংকে চলে আসুক।
If he is giving check, that means he has money in the account. He can operate it from anywhere and do RTGS. He doesn't need to go home. Because if
cash
he
is
is
also
giving
live,
check,
we
that
can-
does not mean that this check will translate into cash which he will bring from home.
No, no.
So therefore, if he is giving check, he has money in
Yes,
the
ma'am.
account.
Yes, ma'am.
That can be made over to the bank through RTGS. Where is the problem? I don't understand any problem.
No, he was having cash of 1 lakh. He brought the cash yesterday. So I said, don't bring cash
Has
in
this
court.
check of 3 lakh. How did he? How would he in any way make payment through the check if he does not
Because
have
he
money
was
in the
having
account?
cash, he will put it in the bank. They will encash it.
So he let him go and put it in the bank, and from there he will do RTGS. RTGS does not require physical movement. He can do it with the click of the buttons.
Branch is in Howrah, so it won't take much time.
No,
Just-
he's agreeable to this.
Just by crossing the Ganges, he'll go there.
Only thing, if this can be done, my lord, he was saying in several amounts within 30th September itself.
Mr. Chatterjee, this is good enough. Go ahead. All these are what? Business loans also, or all
Home loan, business loan?
both?
One account in business was, my lord, defaulted. So all accounts now, my lord, core
Has to
banking
be,
has
has
to
to
be gone NPA. Home loan was not NPA. He was paying regularly in home loan. My lord, only thing that total amount comes.
লিখে নিন। এইটা কি দিয়েছেন দিদি?
দিদি কি বলছে?
কি দিলেন? পাস্ট ওভার সকালে একটা পাস্ট ওভার হয়েছিল তো আইটেম 1। The parties
Lord, I am praying for a short passover, my lord. Mr. Bhattacharya is engaged before the division bench, my lord.
You also deliver the judgment. They
No, you also wanted to place something.
That's why I made the submission. But to that point, when I did not find out any judgment,
You will not be able to find out.
but one judgment I have find out, my lord, when a document should be tendered before a court below, and when the opposite party will file an objection, that is to be taken into account for adjudication first.
Yes, that is there.
But that was not adjudicated.
Mr. Dotto, here the court has merely sent it for being impounded. I mean, court has impounded it. What will happen upon impound? Merely because it is impounded, it will not automatically go into evidence. He will still have to prove the genuineness of the document. Even if it is more than 30 years old, coming from proper custody, the court may presume, shall presume, it is may presume. The court has the discretion to look into the document. The impounding of the document will not make it admissible in the evidence ipso facto. He has to prove that. So this order of impounding is
Then you also pass this order. Then you also pass this.
I'm praying for a short passover.
কালকে রেখে দিন কালকে কিছু ফিক্স নেই তো ask him to be there.
Yes,
then I'll
yes,
dispose
yes,
this off.
yes, I will.
Unnecessarily every day it is pending. नहीं तो 2 p.m. tomorrow. Pass the order, finish it off.
Yes.
I was waiting for your judgment only. Since you said, I indicated you all last day. There is no such judgment.
No, I have tried my level best.
I know.
So there was a Passover matter item number
Yes,
2.
now Passovers may be called.
But I appear for WBCTCL on the last occasion. My lord's order was
I appear
upon
for
the
the
state
petitioner, my lord.
to make an inspection amongst all so that the pathway could be, my lord, sorted out and pathway could be made ready so that we can give connection. Now a report to be filed on that issue.
In accordance with directions, there is a report filed by the BLRO Ramnagar 1. If pilot water logging across the plot number, they are unable to just particular measure the total plot. So they could not demark total, seeking the time for appropriate the measurements.
Yeah. The objection has gone.
Yes, the objection for contempt has gone. May I have a copy of this report?
Let us see what it is. They are taking only time to comply with the order, extension of time because of water logging and all. You can see. That appears to be justified because of the weather conditions.
And on preceding days, my lord, it is stated, I have just gone through. Rain was there, so it is totally waterlogged. The chain work, the handwork which is likely to be done to prepare the pathway, they could not.
They are there, my lord. They are unable to just proceed.
You seek implementation of the order, isn't it?
Yes. So, my lord, they want to implement. It's just that they are saying.
I will keep this on record and extend the time for the implementation to be done. How much time you want?
At least I will do water.
No, but
we are in August now. Lordship gives them a month's time, my lord.
Better after monsoon, my lord. Any season, at least. Still, it will be continued at up September.
I made my first application in 2011. Many monsoons go.
Because there is a low land, my lord. This is the only factor. There is a low land, my lord. This is the only factor.
Yes, but
now, my lord, the good thing is, my lord, they've come with a very positive mindset that they want to implement the order.
At the end of the September, it will be just suitable for us to.
End of September, my lord. I don't
end
mind.
of September. ওটা দিয়ে দিন।
Number
29.
29. Applicant is
Lord, in 29, I am appearing on behalf of the petitioner, my lord.
affidavit of service.
I am for the petitioner, my lord. The matter pertains to, my lord, disconnection of electricity of the petitioner, my lord. What has happened, my lord? Petition connection is in the name of the petitioner, wherein the mother of the petitioner was residing, but the private respondents, being the brother and son of the brother, my lord, ousted the petitioner's mother from that house. Since then, the mother of the petitioner is residing with the petitioner. Now, the brothers are using, the private respondents herein, my lord, are using the electricity on their behalf, my lord. For which, my lord, I have made several applications, my lord, for disconnection of electricity, and they prevented the same. And due to, my lord, kindly comes to page 16 and 20, the CSC authorities were objected from to access the board, my lord. That is the reason, my lord, it could not be disconnected. My lord, I have also informed the local police station.
Electricity connection is in your name.
My lord,
Electricity connection is in your name.
my lord, my name, my lord.
Then if
Milord, the fact is that, Milord, it is a case of voluntary disconnection. The meter was initially in the name of the petitioner's mother, subject to compliance, Milord. The name was transferred into her name. Now, Milord, we have made attempts 4 times. The private respondents, Milord, claiming the petitioner to be their PC, Milord has stated, and in writing as well, that since long they had been using that particular meter and they are paying bills.
So what? If it is in their name,
My lord, I'll avoid very direction, my lord. Let there be, my lord, a direction for police assistance.
if it is in the name of the person concerned, the
My
person
lord, we have made 4 attempts, my lord.
the person concerned does not want electricity supply.
Absolutely. My lord, the private respondents are claiming that since they're deriving.
Not to, you have to go by the law. If they
My
are
lord,
not
we
entitled.
had been there 4 times to inspect and disconnected, but we had been physically, my lord, prevented. So, my lord, there a direction upon us, my lord, to go ahead with the disconnection along with, my lord, police help if required.
How have you
My
served?
lord, my lord.
How have you served the private respondents?
My lord, it has been served, my lord, but they door locked intimation served, my lord.
Door locked intimation served will not, has to come back to you.
My lord, the envelope will also implicate.
Where is the envelope?
Every service already given.
Affidavit of service.
My
only
lord, envelope is with me, my lord. I'm sorry, my lord. My lord, I have stated, my lord, in the track report, your lordship will find intimation served.
all unclaimed. Unclaimed is good service. Only 2 private respondents are there.
Only 2 private respondents.
My
That
lord,
is
my
my brother
They are
and
brothers
son of my
are preventing us from inspecting and disconnecting the meter, my lord. We have made 4 times, my lord, attempts have been made.
They are brothers and the writ petitioner is their mother.
No, they are
Writ
PC.
petition is the sister. Writ petition is the sister of the private respondent.
Sister, he is saying Pishi.
No, 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 no. The petitioner, my lord, is the my lord, niece, my lord, PC of the my lord, the private respondents. Writ petitioner and her brother, my lord, are the legal heirs of the of Shobita Devnath, in whose name the meter was actually there. My lord, thereafter
The meter now stands in whose name?
in the name of Rupali Ghosh.
And she wants it to be disconnected. You have
Disconnected.
to go by her command.
My lord.
Likhen. The writ petition alleges arbitrariness or inaction on the part of the respondent CSC authorities in disconnecting the supply, electricity supply that stands in her name at the subject premises. Full stop, paragraph. You are no longer residing there.
No, my lord, I am not residing there. I am residing in my maternal home.
That meter is being used by them.
Learned advocate appearing.
My mother is also residing with me, my lord.
Advocate appearing for the petitioner submits that the petitioner and her mother are residing at their maternal home. However, the electricity supply that had been obtained by the petitioner at the subject premises is being unauthorizedly used by the respondent numbers 4 and 5, full stop. It is submitted that despite requests for disconnection of the said supply, comma, CSC Limited has not yet disconnected the same. Mr. Ghosh, learned advocate appearing for the CSC authorities, submits that several attempts have been made to disconnect the electricity supply.
Inspect and disconnect. We have not been given even access
To inspect
to the
and
meter box
disconnect
position.
the electricity supply at the subject premises. However, comma, the CSC authorities have been prevented from taking steps in such regard. Full stop. Since it is not in dispute that the electricity supply stands in the name of the petitioner.
The auntie minute of the private respondents.
Maybe in the name of the petitioner, comma. Therefore, comma, it is always within the right of the petitioner to surrender such supply and seek disconnection thereof. Full stop. The private respondents do not have any right to object to such disconnection, such voluntary disconnection at the instance of the consumer in whose name, comma, the electricity supply exists. Full stop. Paragraph. In such view of the matter, comma, this writ petition is disposed of by directing the CSC authorities to conduct an inspection at the relevant premises and disconnect the electricity supply that stands in the name of the petitioner in terms of the petitioner's request, comma, in accordance with law, within a period of 1 week from date, full stop. In case, comma, the CSC authorities face any resistance,
Belghoria police station.
CSC authorities would be free to approach the officer in charge, Belghoria police station, for police assistance, full stop. Upon being approached, comma, the officer in charge, Belghoria police station, would afford adequate police protection to this police assistance to the CSC authorities so as to enable them to execute the job of disconnection of the electricity supply in the name of the petitioner. Full stop. Paragraph. Costs of paragraph now. Costs for such police assistance would be borne by the petitioner. একদম ওপরে এক জায়গায় লিখে দিন তো affidavit of service filed in court today is taken on record. None appears on behalf of the respondent numbers 4 and 5. Full stop. The affidavit of service reveals that the postal article sent to the respondent numbers 4 and 5 has returned unserved with the endorsement unclaimed. ঠিক আছে, তারপরে ওটা বাকিগুলো লিখে দিন। With the aforesaid observations, WPA 17621 of 2026 stands disposed of. There shall be no other.
Grateful, my lord.
Grateful, my lord.
Next.
My lord, I am appearing for the petitioner, the father of my senior expiry day before yesterday, praying for accommodation, not this month, my lord.
An accommodation is prayed for on behalf of the petitioner. List this matter in the combined monthly list of September.
My lord, I appear for the petitioners, my lord.
I for WBC.
My lord, I appear for
Dr.
the
Time for the state.
respondent. My lord, your petitioners, my lord, are the joint title owners over the property, my lord, of the partly by ancestral inheritance and partly by purchase, my lord. Thereafter, since long, my lord, since 9 decades, they are enjoying the property uninterruptedly, my lord. And the private respondents, my lord, made an application for electric connection by which was refused, and then, my lord, on 2025, they preferred a writ petition, my lord, in which, my lord, the WBACDCL, my lord, filed a report, and the honorable court, my lord, directed the learned DM, my lord, to decide. where, my lord, we appeared and made our submissions by furnishing some list of documents and oral submissions, my lord, objecting that over our plot of land there should not be any electricity connections, my lord. And, my lord, the learned DA, my lord, was pleased to pass the order, my lord, which is at page 57. May I place it, my lord? My lord, it is from fourth paragraph, my lord. It is relevant. Upon consideration of the pleadings, documents on record and the submissions advanced, it is found that the petitioner and the objectors are co-sharers of the property, and that the disputed passage has long been used as a passage by all co-sharers without any material objections or obstructions. There is nothing on record to indicate that the proposed alignment would deprive the objectors of their use and enjoyment of the passage or otherwise infringe their property rights. Thereafter, my lord, the Honorable DA, my lord, directed to provide electricity connection, my lord. I am aggrieved with this order on two scores. Firstly, my lord, it is the perverse order, and secondly, my lord, they are not co-sharers. I am coming, my lord. They are perverse order. Yes, my lord. The documents, my lord, based on which this order has been passed is not, my lord, totally, my lord, irrelevant, my lord, that they are not co-sharers at all. They are not co-sharers at all. My lord, there is not a single document, my lord, to establish that the private respondent, he is a co-sharer. My lord, by what, my lord, these co-sharers has been inserted by the learned DA, my lord, I cannot understand, my lord. And moreover, whatever submissions I have made, nothing has been recorded. I said there is an alternative way. Please do not interrupt our property. It is a private land. Please do not interrupt. And if my lord, if there was an alternative line, my lord, they could have make an inspection. I would have understood on the basis of what this order has been passed. My lord, I am aggrieved, my lord, and your lordship can remember, my lord, I came before your lordship, my lord, for leave to move this petition urgently without serving them. But your lordship, my lord, that part is over. They have on, my lord, 21st. My lord, I have came before your lordship, my lord. They made inspection on 22nd and 23rd, my lord. They installed the pole over my land. My lord, it is my case, my lord. I humbly pray, my lord, before your lordship, my lord, kindly direct them to shift this pole to any other place, not in my.
Who is appearing for
My
the
lord.
private respondent?
My lord, paragraph 2 of the page 57, my lord. My lord, the petitioner submits that he is a co-sharer of the property in question and seeks an electric connection to his residential premises through the existing common passage. The connection has been effected on the common passage, and one pole has been installed as plot number 317, and his premises is situated at Dag number 318. Therefore, he will not be affected by this connection.
No.
And my lord, and this is installed in the common passage.
My lord, be produced, my lord. Orally, there. What is, my lord?
How do you say that they are not co-sharers? Where is your pleading?
My lord,
my lord, they are not at all co-sharer. Even, my lord, there is no. Yes, my lord.
Show your pleading before the district magistrate.
My lord, district magistrate, my lord, I submitted, my lord, list of documents, my lord. Kindly see, there is no
that is
yes, my lord, page 38.
Page 38.
Page 38, my lord, I submitted the list of documents, my lord. Kindly see, the most relevant, my lord, is serial number 8. Map of Fatehpur Mauja showing main road and existing electric pole connection from where petitioners can get electric connection. This your lordship will find at page, my lord, at page, my lord, 55. It is, my lord, color page, my lord. Your lordship will find that Gajipara School 2, my lord, this is that, my lord, the broad yellow line is the Diamond Harbour Road. My lord, your lordship find, my lord, On
Yes.
top, my lord, the broad yellow road, my lord, is the Diamond Harbor Road, my lord. And below, my lord, there is a big line, my lord. This is a electric connection, my lord. And my lord, yellow mark, my lord, two yellow portions pole, my lord, from where they can get the electric connection. One is little distance and another is, my lord, old electric pole I have mentioned. I have particularly, my lord, mentioned before the learned DM, my lord, they can get the electric connection from there. Instead of this, my lord, they can get it from even, my lord, your lordship sees from left, old new connection, that will be the lesser length, my lord. They could have get, but instead of that, these red portions are being
Whether
used.
it is your land or whether it is common
Yes, madam.
land, who will decide this? How
Yes,
can a
madam,
writ
BLR.
petition- how can a writ court decide all that?
My lord, read court will not decide. But the thing is, my lord, my submissions were not recorded. And my lord, this order, my lord, is perverse because my lord, these my lord submissions were not recorded, and my lord, there is clearly, my lord, this where from they got the co-sharers. Nowhere in the earlier writ petition, my lord.
What is your basis of saying that you are a co-sharer?
My lord, the recording may be wrong with the word co-sharer. Only that part, he is affected. He is affected by this word co-sharer. 318. My lord, the petitioner along with 27%.
No, but you have also made a submission that you are a
no,
co-sharer.
my lord.
How did you make that submission that you are a co-sharer?
My lord, the petitioner, this private respondent is not the co-sharer with the property with the DAG number 318, but the pole has been installed in DAG number 317 on the passage, and his
observation
40
is
meters
that-
away from the his
His
premises.
observation is that you are a co-sharer with.
My lord, I am not the co-sharer. I'm not the co-sharer of
entire-
318.
The entire order is a fallacious order.
My lord, I am not the co-sharer of the 318. This may be the wrong recording of by the authority. But he is not affected by this connection and by this order, my lord. No, bhai. Page 58, my lord, paragraph, second paragraph. And his property and his right has not been affected. The proposed
If
electrical
the
installation.
if the pole is erected in his property, how his right is not affected? If the pole has been erected in his property, his right is
No.
affected.
Then no, this has not been done.
Yes,
My lord,
my lord,
the
it has
pole
been
has
done.
the pole has been installed in DAG number 307.
I will direct the DM to reconsider the issue and
No, my lord, let there be an inspection. Let there be
DM
an
will do
inspection
it
by the
and
BLLRO.
Your own averment is that you are not a co-sharer. The
My
DM
lord,
has
I'm not the co-sharer of
Very well. The
380.
DM has proceeded on the basis that both of you are co-sharers. Then the DM will have to decide
And
whether
there is a rider also, paragraph,
DM
second
will have
paragraph,
to
58
decide
page.
whether the pole has been erected on his secular property or on common land. If the DM finds that pole is on his property, it will have to be shifted to a common land. It cannot be continued on his property.
I'm grateful, and
No
another
problem.
thing, my lord,
No
I have
problem.
submitted.
And
my lord, another thing, my lord, I submitted. My lord, there is an alternative route.
Since there is a since there is a
passage.
direction, my lord, to effect connection within 7 days, we have done it. Now, my lord, if subsequent to the hearing, DM says it has to be shifted, my lord, the cost to be borne by the person.
Not the petitioner, because the DM has done it in terms of the private respondent submission that he is a co-sharer.
So, my lord,
Therefore, the cost will have to be borne by the private respondent.
private
Why should
respondent.
the petitioner bear
Yes,
the
yes, my lord, that will not be saddled upon my lord WBSC issue.
No, no,
If it is installed in the 318,
if it is
DAG
found
number.
that it is installed in his land,
Yes,
then
yes,
in
grateful,
that
my
case
lord.
he
Yes.
will have to bear the cost. I will make it
Yes,
clear.
yes, no problem.
My lord.
My lord, it will be better if direction is been given to the BLLRO to inspect the lands
DM will,
also.
The DM will involve all of them, will hear you, will hear him, all of you will be heard.
Lordship.
And then the decision will be taken. Just for the sake of equity, it has to be done, because if it has been the DM's observations are wrong. This writ petition, a sales and order dated July 2, 2026, passed by the District Magistrate, South 24 Parganas, pursuant to an order dated March 12, 2026, passed by a coordinate bench of this court in WPA 26680 of 2025. Full stop. Paragraph. The petitioner, the private respondent, number
private respondent number 8, my lord.
The private respondent number 8 had approached this court by filing WPA 26680 of 2025, alleging inaction on the part of the WBSCDCL authorities in effecting electricity supply to the private respondent's residential premises. Full stop. The said writ petition was disposed of by an order dated March 12, 2026, referring the matter to the district magistrate in terms of the works of licensees rule, 2006, and directing the district magistrate to relevant district magistrate, and directing the district magistrate to adjudicate upon the grievance of the petitioner as regards the petitioner's separate electricity connection. Full stop. Paragraph. Pursuant to the said order, the district magistrate passed the order impugned herein on July 2, 2026, thereby directing the WBSCDCL authorities to effect supply in favor of the private respondent number 8 through the proposed alignment. Full stop. Paragraph. Such connection has been supplied to the private respondent number 8. The petitioner is aggrieved by the aforesaid order dated July 2, 2026. Full stop. Paragraph. Learned advocate appearing for the petitioner submits that the district magistrate has proceeded on a wholly erroneous basis that the petitioner and the private respondent are co-sharers in respect of the property in question. Full stop. Paragraph. It is further submitted that the order dated July 2, 2026 is wholly perverse, inasmuch as none of the documents relied on by the petitioner was looked into by the by the district magistrate while passing the order impugned. Full stop. It is submitted that in terms of the said order, while electricity supply has been given to the private respondent number 8, a pole has been installed / erected on the petitioner's land. Full stop. Paragraph. Learned advocate appearing for the private respondent fairly submits that the recording that the private respondent number 8 and the petitioner are co-sharers in respect of the property in question is factually incorrect, inasmuch as inasmuch as the private respondent is not a co-sharer of the petitioner in respect of the property in question.
That number 318, my lord.
I will record that. It is further submitted that, however, such recording would not affect the petitioner, inasmuch as the pole has been installed at DAG number 308.
317.
307. DAG number 317.
On the common
And
passage.
the petitioner is the owner of DAG number 318.
Lordship.
Full stop. It is submitted that since the pole has been erected on a property which is not owned by the petitioner,
Lordship.
therefore, the petitioner has no reason to make a grievance.
Lordship, I'm grateful.
The DAG number 318 is panchayat or common property? What
Madam,
is
370 is a common passage. The panchayat.
There is no
It is
common
submitted.
passage at all.
Very well.
It is my grievance.
Let me record his submission.
Yes.
It is further submitted that DAG number 318 is a common passage.
No, my lord. 318 belongs to the petitioner and 27 other persons.
317 is a common passage.
317 is the common passage.
That DAG number 317, where the pole has been installed, is a common passage. 317 is a common passage.
Lordship.
318 are common.
I know, my lord. 318 is my property, my lord. They are.
Let them make the submission. You make your own
my
submission. Yes.
317 is the common passage.
317 is a common passage. Full stop. Yeah, 317 is yours or
318.
318.
Full stop. The petitioner, however, submits that the pole has been installed at DAG number 318 and not 317, and DAG number 318 is owned by the petitioner along with 27 other persons. Is it so?
my lord 27
Yes, my lord, it
my
is
lord, I have
annexed.
not
আচ্ছা, ওটা
instructed
কেটে
my lord
Yes,
27
49
I
page,
am
he
not
has annexed the document. Page
no
49.
20 my lord 318 and my lord others my lord I am stated in paragraph 3 my lord kindly see my lord I have stated in paragraph 3
so it is owned by you along with others.
Yes, my lord.
yes I am jointly the title owner and my lord partly my lord purchase the
Maybe.
300
So along with others.
yes my lord along with others but not 27
27 টা কেটে petitioner submits that dag number 318 is owned by the petitioner along with others. Sufficient.
grateful.
Full stop. Paragraph. Learned advocate appearing for the WBSCDCL authorities submits that the WBSCDCL authorities have acted strictly in terms of the order passed by the district magistrate. Full stop. Paragraph. Heard learned advocates appearing for the respective parties and considered the material on record. Full stop. Paragraph. It is not in dispute that the district magistrate has proceeded on an erroneous basis that the petitioner and the private respondent are co-sharers in respect of the property in question. Full stop. The order dated July 2, 2026 does not reveal that any document that has been submitted by the petitioner or the private respondent has been considered while arriving at the ultimate conclusion. Full stop. In such view of the matter, comma, while the present arrangement of the private respondent getting electricity supply is not being disturbed, comma, the matter requires to be reconsidered by the district magistrate once again. Full stop. Paragraph. Accordingly, comma, the matter is remitted to the file of the district magistrate for reconsideration. Full stop. The petitioner as well as the private respondents will be entitled to place their documents before the district magistrate. Full stop. The district magistrate will get a fresh inspection conducted
by the
block land and land reform or any other competent officer which the district magistrate may depute for such purpose. It would be specifically ascertained by the district magistrate as to whether the pole has been installed on the property owned by the petitioner or on a common land.
Lordship.
Full stop. In case it is found that the pole that through which electricity is being supplied to the private respondent has been installed at the property of the petitioner, comma, then the district magistrate would pass appropriate orders for shifting of such pole from the petitioner's property to a common position so that electricity supplied to the private respondent may be continued therefrom. Full stop. However, comma, since the petitioner is not to be blamed for the erroneous installation of pole over the petitioner's property, comma, if it is found so, comma, the costs for such shifting would have to be borne by the private respondent. Full stop. It is made clear that this court has not gone into the merits of the claim made by the petitioner as well as by the private respondent and the aspect as to whether the pole has been installed on the property of the petitioner or not will have to be ultimately decided by the district magistrate, and consequential orders for shifting thereof would be required to be passed in case the same is found necessary. Full stop. With the aforesaid observations, comma, WPA
18192
18192 of 2026 stands disposed of. এর উপরে একটা লিখে দিন. The district magistrate shall endeavor to conclude the exercise as aforesaid as expeditiously as possible, and preferably you are appearing for the state, and preferably within a period of 8 weeks from date. Full stop. The needless to mention that the district magistrate shall pass a reasoned order and communicate the same to all the parties within a week from passing thereof.
Only one thing, my lord, at the time of inspection as well as hearing, my lord, the WBSC DCL is
আচ্ছা
also-
ওখানে আরো একটা লিখে দিলেন, এটাও যেখানে ইন্সপেকশনের কথা লিখেছেন সেখানে যোগ করে দেবেন. The district magistrate shall ensure that the uh, officer conducting the inspection gives adequate advance notice to the petitioner, the private respondent, as well as the WBSCDCL authorities, so that the inspection is conducted in the presence of all parties.
My lord, WBSCDCL along with my lord respondent number 6 and 7, because they are the BL and LR and BDO.
Yes, that I have said so.
And my lord,
devise his mechanism.
and my lord, if this map may kindly be considered.
That he will consider, because I will not describe how he is to decide.
My lord,
Decide in his own way.
Another thing, my lord, earlier occasion, my lord, I forgot to file affidavit of service. Those all appeared, my lord.
Affidavit of service filed in court today.
I'm
WPS
Deeply obliged.
Next.
Dada, এটা নিয়ে নে।
I'm for the video.
I am for the.
I have to file the affidavit of service lawsuit. Lawsuit last occasion, you lawsuit directed to serve the copy to the notice of the copy to the private respondent number 11. Service was effected on 10th August lawsuit. And last occasion also, lordship, the hearing was on the ground that the petitioner is an existing WBSCD consumer having the submersible pump, lordship, and the respondent authority intend to effect another electricity connection to within 40 meters of the petitioner's existing connection, lordship, without inquiring any hydrological examination and transparent loading capacity, cumulative groundwater extraction, environmental impact on technical grounds, whether the extracting capacity having to flow the electricity connection and the water level connection, aquifer connection. On that,
it is not under semi-critical or critical zone.
yes, lordship. On this ground, there are various judgment, lordship. I have.
Well, it is not critical, semi-critical zone. Geologist has already passed it.
Be supplied, lordship. Hydrological inquiry report to be supplied whether the extracting capacity was there or not. The petitioner was raised on that ground objection, but no report has been supplied to the petitioner. The report.
You are not required to be supplied.
No, lordship. My connection, my well has been suffered, lordship. I am existing consumer, lordship. Yes, lordship. I am suffering, lordship.
Objection, they will keep on supplying reports.
No, lordship. If the water level having the capacity to water extracting capacity, then that to be neither. Yes, lordship. Obviously, geological department will decide, but that report to be supplied to the petition having the capacity to extract the feasibility capacity or not, that was inquired and objected by the petitioner by the representation.
Is your authority to call for the report? Who are you? That report has to be supplied to you every time. Merely because you object, they have an obligation to supply a report to you.
If that decision is arbitrary, that to be interfered by the Honorable Court.
That is for the court to decide, not for you to decide.
No, lordship.
They have submitted a report before the court. You can seek a copy of the report, because
then they have to supply the copy.
Give a copy of the report to her.
Actually, Miller 2005 Act clearly says 30 cubic millimeters should be lifted. Then 5 horsepower. So there is no bar distance.
Lordship, they'll give it at 2 p.m. Lordship. I have going through it, lordship.
What 2 p.m.?
I will not be able to keep it.
Pass over, lordship. Make it pass over. Then I have to go through it, lordship.
What
I have to gone through it. There.
It's 3 lines.
What will waiting for this? Unnecessary time
Absolutely
will be.
frivolous
Necessary time has been wasted.
ও আপনার decision দেখলে তো হবে না
5 lines
রিপোর্টটা
time
দেখতে
will
হবে
be
তো
wasted. Please go through and say whatever you have to say.
He is the authority. Geologist is the authority.
Yes.
আরে এগুলো বেকার মামলা unnecessary আছে ব্যবসা বন্ধ হয়ে যাচ্ছে না
लिखे नहीं this repetition
I appear for respondent number 3, Lordship. The maintainability of the writ petition has to be decided first because the writ petition is not maintainable on threefold grounds, my lord. First of all, it's an NBFC.
My lord, may I continue, my lord? My lord, I have served. Just a minute, আমি শেষ করে যাব।
Sure.
My lord, I understand, my lord, the maintainability point is there. My lord, I tell your lordship, my lord, pursuant to your lordship's order, my lord, we have served. But my lord could not serve these three persons, private respondents, because my lord, we were not aware about their address. And my lord, we requested the financial corporation, that is L&T Finance, to supply their address so that we can serve. But my lord, nothing they have communicated. Now, my lord, point is this, my lord, we have this is the letter we sent to them. Now, my lord, this is the matter, my lord, where we have not taken a single paisa from the bank. I understand, my lord, this is a proceeding under Surface Act. Now, my lord, your lordship kindly see, we were not party to the proceeding at any point of time. And there was a development agreement where our portion was specified in the agreement. And my lord, we are holding, my lord, only those portions, except that we are not holding any portion. If the portion of ours belongs to us, if sold by financial corporation without going through the documents, examining the documents, where the Supreme Court has observed that before you give loan, you must be satisfied about the documents. Well, here is Supreme Court decision, my lord. I am placing that, my lord. But this is the case where, my lord, all on a sudden, we were on a Saturday or no, on a Saturday or Sunday, some police personnel came there, and my lord started saying that, my lord, go out of the room. And my lord, we are actually, my lord, we are residing there with our families, and we are the owner of the land, no doubt, my lord. There was a development agreement where our portion was very much specified, and we are still.
Who created the mortgage?
That's it. Mortgage has been created by Uday Sarkar, Registry Ghosh, and there are three separate properties in respect of which mortgage has been created.
And their addresses are not known. This is for the first time we have come to know.
The respondent company is holding a valid title deed, my lord. Now, this is a disputed question of fact. Whether the developer had the authority or not, whether this exact portion comes within the landowner's allocation or developer's allocation, these are to be decided by a civil court, my lord, upon appreciation of the evidence, my lord. And this, they have, in order to get the relief what they are praying for, they have to seek for cancellation of the registered title deed, which are standing in favor of my borrowers, my lord. So this cannot, all these aspects cannot be decided in a writ court, my lord. I'm having a valid mortgage over those properties, my lord.
I can sell a property belonging to him, claiming myself, I am the owner, and my lord, title deed. I tell you, lordship, my lord.
Development.
Mr. Moitro, you have a remedy.
My lord, I tell you, lordship, my lord, your lordship, my lord, before that, your lordship will kindly, my lord, have a look at, my lord, page.
Very well, we can have it tomorrow then.
My lord, only one, instead of tomorrow, day after tomorrow, will your lordship. Day after tomorrow, kindly, my lord. Yes, grateful to your lordship.
Also, it's there in the order.
That's right. My lord, I
just to assist him, I'm supplying that.
I am grateful to my lord, if you know. The address go to, you know, the address go.
So, should I keep it then next week? In the meantime, you'll be able to serve them.
Well, I will try. Yes, keep it on next week.
Mr. Mitrul on its senior advisor.
Milord, liberty to mention, Milord. Milord, there is a probate matter for final disposal, Milord.
May I be permitted to make
Deep
one
down.
application for inclusion for discharge?
The letter and the letters are we are getting it print out. We will give it to your lordship, and we can your lordship can
The
grant
accounts will be defrozen then.
My
Your
lord, so my lord, in that event, my lord, the impugned order
will go.
disposing of my objection should go. Along with my
It's
lord,
because you can't have a freeze now because
No, you
the
cannot.
substantial portion of what was supposed to be
everything, and
freezed
for
has
the
already
balance, we have paid 20%. For the
and
balance,
the balance 20% has
your
been paid.
lordship. Your lordship may kindly see the top portion of the letter and the attachments. It is getting printed, your lordship.
that is payment.
Petition press A and B can be alone.
Let's come to the prayers.
For revocation of attachment, letters have been issued is what they say.
So, my lord, also, my lord, this form ITCP 1, which is annexure, page 11 of the supplementary affidavit, that's the action taken by TRO should also go.
What is that action?
My lord, your lordship may recollect, my submissions were regarding, my lord, that once the TRO assumes jurisdiction, the jurisdictional assessing officer cannot take action.
All actions on the basis of this will go.
All the actions will be. Page 63 is pair A and B, my lord. Page 63 of the writ petition.
That is point number 8.
All attachment orders will stand set aside and the accounts will stand frozen. लिखे नहीं. This writ petition has been filed challenging orders of attachment dated
This is my application. Amendment of July. But there are two parts of this amendment. If your lordship kindly goes to page 19 of my application, that is the proposed amendment. 19. First of all, the name of the bank is being changed and address of the bank. 2 and 4. 2 and 4, page 19. Fixed is the new inclusion since it's a fixed deposit receipt. That fixed deposit because for that reason your lordship directed me to sub notice. Now I have received instruction that my client is not searching out, is not available that fixed deposit. So if you are interested to amend that portion, only 1, 2 and 4 that will sub.
What 2 and 4? I don't understand. I don't understand. What
2 and 4?
2 and 4 means?
Amendment below. Lordship kindly go through it. 2 and 4. United Bank of India. Now it has become merged with Punjab National Bank. So the name of the bank is being changed and address of the bank. And 4 is address is also being changed. And minute 6 is the new asset. That is fixed deposit receipt.
No, but why should you not serve? You serve and come. If there is a direction for service,
For
you
that
serve and
reason, Lord, I have received instruction, Lordship.
So what? If you have received instruction, if they don't have objection, they don't have objection even to that. What is the
probate has
problem in
already been
serving?
granted in 2024.
So what?
And your lordship was pleased to observe because of the past 2 amendments, no notice is required. And since because of the new inclusions, notice is
The order does not say that only
No, no,
because of
order
first
does
2
not say-
amendments.
Order does not say that. So
Order does not say that
for
only because
that
of the
reason,
first 2
we have
amendments.
not served, Lord. And instruction we have received. Very simple amendment, Lord, on the name of the bank.
There is a direction to serve, you please serve.
Yes, that
Serve
I
and,
shall serve. Yes.
there is a direction to serve, you
Yes,
serve
that
and,
I shall serve.
serve and come, and then I will allow this. But
Yes,
since there is a direction, I will not supersede that.
Then can we adjourn for 2 weeks, Lord?
लिखे नहीं? Service in terms of the order dated July.
Last occasion, there is an application GA1 for reconstruction of that probate petition because due to water soaked, it got destroyed. My lord has seek for a report.
The record has been found out.
The record is there, my lord. But if my lord kindly looks at the will and the affidavit of consent, it has been completely damaged.
It is readable.
If it all writes to my lord, then I have no difficulty. But today, tomorrow, if the determination gets changed, my lord, then I will have difficulty.
Where is the affidavit of consent?
तो আছে দেখো
এটা নট দিস উইক করুন, আমি রেকর্ড গুলো একটু দেখে নিই, তারপরে অ্যাপ্রোপ্রিয়েট অর্ডার পাস করে দিই। ঠিক আছে, ঠিক না? হ্যাঁ, নেক্সট উইকে করে দিন। I'll go through the records and I'll pass appropriate orders next week. If reconstruction is required, we'll reconstruct, and otherwise we'll proceed on this. Not a problem. Item number 4, originals are sufficient. Why should we?
It is sufficient because on the last occasion when my lord Justice Kapil taken up this matter, my lord, he was of the opinion that I should.
Very good.
For my lord, I appear for the petitioner. This is my application for grant of probate. Lordship will recall in this particular matter, every formality has been complied with, my lord. Citations have been issued, paper publication is completed as well. However, there is a minor error in the will. That is, it should have been the word should have been husband. If Lordship kindly takes up my application, my lord, may I just indicate the error? My lord, the will, first page of the will, my lord.
Page of the bill.
Yes, my lord. My lord, will kindly see the first line. This is the last will and testament of Srimati Pratima Ghosh, wife of Amit Ghosh. She is indeed the wife of Amit Ghosh. Now, Lordship will kindly see paragraph 2, the 7th line, my lord. 7th line records my husband, Nirod Boron Sarkar. Nirod Boron Sarkar was the father of the testatrix, my lord. This is the only error in the will, my lord. That is, it should not have been husband, it is only the father. Now, Lordship, the Honorable Coordinate Bench it had fallen from my Lord Honorable Justice Arindam Mukherjee that because of this error, we should file an application indicating that there is an error. But Lordship had also directed us to cause searches as to whether wills can be touched by the Honorable Court. We could not find any provision or judgment to that effect. Those are there in foreign laws, my Lord, in UK and Nigeria, to whatever I have done research, not here. However, Lordship, I have found judgments which says that minor clerical error in wills will not stand in the way of grant of probate. If Lordship so
Application for correction of that.
no, it was not essentially for correction, my lord. My prayers were that name of Nirod Boron as appearing in the 7th line of the 2nd paragraph in page 1 should be read as father and not as husband. We wanted a direction to record that there is an error.
Is there any other place in the will where her father's name has been recorded of the
No,
father
my
of
lord.
the testatrix?
No, my lord. Although we have other documents to show whose wife she was and whose daughter she was.
Those documents have been annexed with.
Yes, my lord. It has been annexed with the GA application, Lordship. Will kindly see. Lordship will kindly take up page 10 of my application, my lord. Lordship will kindly see, I might be a little less legible. Serial number 2, Pratima Ghosh, in the next paragraph, wife of Sri Amit Ghosh. And these are the legal heirs.
No, but that she is wife of Amit Ghosh.
And that is also
Problem because that is there in the will also.
my lord.
But
So, my lord, this particular page.
Sarkar is his father.
Yes, this is the certificate, my lord. My lord will kindly see the first paragraph. I am directed to refer to your letter such and such on the subject noted above, and by order of the governor to say that the governor has been pleased to allow mutation in respect of plot number 6 in block such and such in sector 1 of Vidhannagar in favor of the marginally noted names as the legal heir of late Nirod Boron Sarkar, the original lessee of the said plot, who died on 15th of July 1984. And Lordship, in that particular table, it has been indicated that Pratima Ghosh is the daughter of the deceased lessee, my lord, and she is the wife of Amit
The
Ghosh.
only document you have.
My lord.
The only document you have.
Yes, and the death certificate will also show that she is the wife of Amit Ghosh. Yes. Yes. So far, Lordship, we've only found this.
Of Nirod Boron Sarkar. Where is the lease deed? This 1977 lease deed?
I will have to seek instructions, my lord, then for the lease deed.
And,
Yes, my lord. I'm not sure if it is. I'm not certain, my lord, if we have it with our records. Lordship will kindly grant us some time. 2 days' time, I will check up, my lord.
Problem. Time is not a problem. We have to find a solution to the
Yes, my lord.
For, what is the age of the tested? What was the age of the testatrix? 1977, when this document was executed.
My lord will kindly grant me a moment.
Of the death certificate, she was 61 years in 2023.
Yes. My lord, when this particular document was executed, the one that I've just placed before my lord, she was in her 30s, lordship, because this was in the year 1990. That is when the succession certificate was granted in favor of the wife, son, and daughter.
Some age,
Yes.
considerable marriageable age. That also does not dispel the doubt. If she was, say, 1 year old, 1977, 2 years old in 1977, that would have dispelled the doubt immediately.
Mhm. However, lordship, all other requirements are complied with. We have.
The problem is correction of a will, whether the court can do it.
My lord,
Waiting for that.
we are not pressing for that, my lord. If lordship permits, we are only seeking for grant. Whatever little, my lord, I have done my research, lordship. At this stage, the honorable court perhaps does not have the power to touch a will. However, possibly after grant of probate, a probate can be modified subject to correction by my lord.
Absolutely right. Absolutely right.
Nobody has come up to challenge the execution of the will. Citations have been served, issued. Paper publication has also been
But
affected,
your
my
own
lord.
application stands in the way. We are tried a GA.
Yes, this was. We will, if lordship will direct me, lordship, I will withdraw this particular GA because the probate may be granted, my lord. It's a minor clerical error. And I'm carrying decisions in my support as well. If lordship so desires, my lord, I can place those, my lord. This is a 3 judges bench of the Honorable Supreme Court. Lordship will kindly take up paragraph number 11.3, my lord. May I place, my lord?
Yes, 11.3 I've got.
Elaborate provisions have been made in Chapter 6 of the Succession Act in sections 74 to 111 for construction of wills which in their sum and substance make the intention of the legislature clear that any irrelevant misdescription or error is not to operate against the will. And approach has to be to give effect to a will once it is found to have been executed in the sound state of mind of the by the testator while exercising his own free will. So, my lord, I say that though nobody has come up in challenge, lordship. So, effectively, the will has been executed. I have proved it. And my lord, if lordship so allows me, it might not be very convincing, lordship, but because I was doing some research, my lord, and the only thing I could find was this, lordship, is
70. এখানে নেই ওই লাল কুড়িটা আছে সেশন এক নেই it after a week.
My lord. If I find something, lordship, may I place it on that day?
Try to find.
Lordship. I'm deeply obliged, lordship.
Yes.
The legal age of the deceased, my lord, service is not complete. My lord, kindly give me at least 15 days time so that I can complete my service.
Service in terms of the order dated July 21, 2026 is not.
Great point.
Item number 6, if Milord remembers, Milord had granted me leave to file a supplementary affidavit indicating that there were two marriages. Milord, first wife and then and the names of their legal heirs, Milord. Pursuant to the leave granted, but I have filed the supplementary affidavit, though it is recorded in the will by abundant caution. The executor, my lord, is the elder son. And my lord, by an order of 28th July, had granted the probate of the mother of the testator here. All these three people are here. Yes, ma'am. All their consent affidavits are there. The affidavit of the attesting witness is also there, my lord. The named executor has filed the application. If my lord takes the will at page 11, you will find this mentioned therein, my lord. Now, the death certificates, my lord, will also find from page 10. And in the other one, which I had allowed, all of them, all the averments were there. Yes. Other one was the mother, my lord, so there was no requirement. Should I, my lord, indicate the page numbers one by one? I'll go through them. I'll look in. Acha, ek to previous order, just second. But may I just hand over the previous one? Should I hand over the previous order, my lord? The mother. Not required because this is different. Yes. Death certificate of the testator is at page 10. The will starts from page 11. Both the wives are not there. Second wife is alive. She is there. Second wife is alive, that is mentioned. And the first wife is not there, who's for which you had to file this affidavit. Yes. Supplementary affidavit. Though it was mentioned in the will by abundant caution, my lord. Affidavit of consent of all the three others is there, and Rajesh Kumar is the executor. Yes, ma'am. The no intimation and endorsement is also at page 70. I have paid the maximum duty, my lord. My lord will find that at page 18. Supplementary affidavit filed in court today is taken on record. very obvious.
But this for grant, the non-contentious cause, my lord, there's only one issue, my lord. The beneficiaries, uh, they have effectively entered into terms of settlement, which, my lord, I don't know how to go about it. They want to change a part of the bill.
How can that be done?
Yes,
Part of the will.
because well, if your lordship sees internal page 20, I'm sorry, my lord, in 20 is, my lord, where, my lord, the bill starts. And, my lord, there is one part, internal page 7 of the bill. I understand, my lord. Otherwise, my lord, there is everything is in order. But the affidavit of assets are there, my lord, the attesting witnesses have given their affidavit. My lord, 3 children of the deceased, 2 are executors. One daughter has been the attesting witness who has given the affidavit, and the other son, who was also there while the will was executed, has signed as the attesting witness.
Sons and one daughter.
Yes,
Two sons are executors.
joint executor.
And the daughter has given consent.
Given consent by declaration of by way of an affidavit, and one of the sons was also the attesting witnesses.
One of the sons is the attesting witness also.
Yes.
And what happened to the wife of the testator?
Predeceased in 2007. It's provided for in the will.
Written in the will.
Yes, my lord. My lord, paragraph 3 of the will. I am married to Shakuntala Bajoria. She expired on 17th April 2007.
to
Yes, my lord, after that, if
after
they,
the will is executed,
after the will is administered, my lord, thereafter by way of
after the execution is done,
rejecting the prayer.
then they
There
will
only
have
one thing may I pray for, well, only for the, because of the instructions that they have entered into terms of settlement, lordship can may, if it's so convinces to your lordship,
it won't
well,
be
lordship can record it and reject it. Very well. I know it can't be done. It's
I will
impossible.
not have jurisdiction.
It's impossible.
Only the genuineness.
I know, my lord. I'm great.
Item 8, non-contentious, everything has been complied with. Legal heirs have given their no objection. Also, the attesting witness has provided with the affidavit.
Wife of the deceased.
No,
Wife of the deceased.
wife, Milords,
The deceased has predeceased him. Or
no, Milords, a wife is the testator. The testator has
husband is the
bequeathed
heir.
the husband.
Sorry. Listen. This is an application.
Is your lordship, my lord, application for letters of administration without a will. Now, my lord, this is a joint estate of my maternal grandfather and grandmother. My lord, relating to, my lord, share certificates. My lord, we could not come before this court, my lord, at the first instance because we did not had any idea. Because it was communicated in the year 2019. Thereafter, we found that certain shares, my lord, remained in the name of my maternal grandfather and grandmother. So therefore, we have approached. My lord, if your lordship kindly takes the genealogical table for once, my lord, annexure F, your lordship will find that I am here, my lord, claiming letters of administration, annexure F. My lord, I am here, my lord, claiming letters of administration of Dhirendranath Nag and Srimati Roma Nag's, my lord, estate. My lord, they had, my lord, only one daughter, Moitri Ghosh, who has expired. My lord, I being one of the petitioner, my lord, I'm rather the only petitioner, Anuradha Mitra. And my lord, there is a consent affidavit, my lord, signed by Orpita Sarkar, my sister. So therefore, my lord, there is no contention raised by any of, my lord, the legal heirs. My lord, there is none except, my lord, Orpita Sarkar. So my lord, I am just praying, my lord, for letters of administration, my lord, in respect of those shares.
What about Arpita Sarkar?
She has given her consent, my lord.
Yes,
The
given her
consent affidavit is there in the records, my lord. Lord, E, annexure E. And everything else, my lord, has been explained, my lord, in from paragraph 4 of my petition.
Very well. And let this come after a week.
And my lord, there's an application pending.
No, no,
What are disposed of? Oh, disposed of.
been withdrawn.
Withdrawn. My lord, jurisdiction.
One difference.
Grateful.
ये दे बेटा. Next.
Great.
This is my client's application for grant of probate. The lady Shakuntala Devi Prahlatka, she died leaving two sons and one daughter. The daughter and the one younger son has given consent, and the eldest son is the executor, and he has filed this application. The affidavit of assets are also here, my lord. And consent has been given by Mr. Vinod Kumar Sharma. I am now praying for grant of probate of the last will of that lady, testatrix, on dated 11th of January 2010.
Your Lordship will also find the English translation of the signature made in the will in Hindi language, only the signature part.
Or there is a report by the department. I think you should go through the report.
Lordship.
I'll keep it next week. You may have to say something after you go through the report.
My Lord, he had indicated to, I don't know what he has written. Therefore, I'd like to go through the report.
Yes, I'll keep it next week.
Very well, my Lord, a copy may be supplied to me.
Go through it, I'll just indicate into it. You inspect it. The
Oh, but see, the petitioner is the owner of the land, and licensee company has drawn electric connection over the land without any consent of the landowner, my lord. To the private.
Connection was given in 2014, my lord. We have just changed the mode of transfer. It was earlier naked low tension line of existing of 63
Affidavit
kVA.
of service filed in court today is taken on record.
Chalo, chalo. 35, my lord, Mr. Anirban Das was appearing. My lord, he is not present in the court in the second half, my lord. He has requested me to pay before you for only 1 day adjournment, my lord.
Not today.
Not today only, my lord. Much obligation.
My lord, I am appearing on behalf of the petitioner.
For the CESC, my lord.
So this is the affidavit of service. In respect of private respondent, my lord, item delivered. But this writ petition is for, my lord, new electric connection. My lord, facts of the case is that, my lord, the petitioner is a lawful occupier of the premises.
Have any objection?
My lord, we could not hold the inspection because there was objection at site from the private respondent. So unless we hold the inspection, the feasibility cannot be asserted.
Due to the objection raised by the private respondent, my lord,
Dispute. And my lord, unless we hold the inspection, we are not in a position to assess the.
due to the strong objection raised by the private respondent.
Police help is required. my lord.
Affidavit of service filed in court today.
The court had directed that the auction sale, which was conducted on 5th
What
August.
happened to the auction sale?
My lord, I appear for the respondent numbers 3 and 4, my lord.
This
So
is
we are
the
the assignors.
assigner, my
We have
lord.
assigned the security interest to the respondent number 5.
That service has been completed. My lord had directed service again. All the private respondents.
You
my lord.
appear for 3 and 4.
I appear for 3 and 4.
That is the
So,
assigner, my lord.
my
5
lord,
is the assignee, my lord.
from the petition I find we have possibly issued the 13.2 and 13.4 notice.
Yes, my lord.
I have only been briefed today, so I just went through the petition, and from the petition I find that.
There are questions now as regards maintainability of your writ petition. There is another matter which is going on, has been fixed on Friday. Asset reconstruction companies would not come within the
The
zone of
purview.
NBFCs.
My lord, the action has been initiated on the NBFCs, my lord. So, my lord, my lord understands that
Not a
it was
problem.
at the time when the action was initiated, my lord, what the law was and the steps taken in that regard, my lord, that is where this issue comes into play, my lord. Also, my lord, there's a division bench which still holds the ground, my lord.
Division bench did
There
not
was
have
no
this
assignment.
question
No, my
before
lord, not that assignment is occurred was not the issue before the
There
division
was
bench.
no assignment in the division bench
did
as
not
well.
consider the issue as to whether this assignee can proceed with it or
But
not.
my lord, yes.
So when the assignee is the asset reconstruction company.
My lord, but the assignee is invoking its rights on the basis of the action initiated by the assigner, my lord. My lord, the assignee has receivables only because the assigner has.
In case
demand.
because of federal bank, why should the writ court intervene? Because it is again a private action. If I go that way,
My lord, but the writ court has already intervened, my lord. It's a single
the
bench.
federal bank was not brought to the notice of the either the single bench or the division bench. Federal bank, Muthoot Finance.
But
What happened there? Why don't you inform your assigner? I mean assignee.
My lord, I will try, my lord. I will try to take instructions. I've just been briefed today, my lord. So my lord, in fact, I was going to take that point before, my lord, that assignee possibly will not fall within that threshold category.
But what will
So,
you have to say with regard to the initiation of the action being wrong?
yes, my lord, I would, possibly once the assignee takes over, my lord, in that case, my lord, 13.2 action would become valid, because in that case, there is no threshold applicable to the assignee itself.
But if the initiation is by you and the initiation is bad, can the subsequent assignment cure the defect at the threshold level?
My lord, on that account, I'll have to, my lord, make myself ready a little bit.
The sale you don't know, nobody knows.
No, my lord,
also try to inquire.
Inform the
we will do that, my lord. We will do that. We will do that.
the assignee. I'm keeping it on 14th only, so that on that day the other matter is also there.
Yes, my lord. 14th, my lord. I will
Liken it.
rest my fate to the 14th.
Affidavit of service filed in court. এটা ওই 14 তারিখে আরেকটা ম্যাটার
My lord, I am appearing in person in item number 38.
The respondent
My
bank.
clerk is there.
I'm
My-
instructed that on behalf of the respondent bank, my lord, the
He only wants expeditious disposal of the applications before DRT. So nothing adverse.
Well, the advocate on record is, my lord, not instructed, my lord. I'm praying for not this week only, my lord.
No, my lord, they have obtained ex parte order without issuing the summon. Please go to the page
I will not interfere with the order, Mr. Pitti. I will not interfere with the order. You want expeditious disposal?
That's all. Okay. Well, DRT3 is not sitting.
So I cannot. DRT3 is not sitting. Therefore, High Court will discharge the duty of DRT3.
No, to some other DRT, some other tribunal.
Before no other tribunal, before the judge in charge, you know the methods. Please go and argue it before the person.
Okay, no problem. Just expeditious disposal.
Only 1 week accommodation, my lord. Only 1 week accommodation, my lord. I'm praying before you, lord.
It is just for expeditious disposal of the applications. It's not on merits. Nothing on merits.
As your lordship.
Missing diary number 1129.
This writ petition seeks expeditious disposal of the petitioner's miscellaneous application being MA number 1129 of 2025.
My lord, this is diary number. This is not my MA number. It's still diary number
Prayer,
pending.
your prayer shows MA number. Please read
Okay,
your prayer.
that is my mistake. I do not know, but it is still diary number. But they are showing still diary number.
Where is that? Show me the application, the records.
My lord, then allow me to file new. I will file new application.
What do you want to do with this?
Dismiss that, no problem, sir. I have mistake. My clerk has mistake. There is supposed to case it.
No, you must have something on record to show that it is diary number. Show me that. I will then accordingly pass the order.
That is the requirement. I have played in the page number case status to be attached, but page number 2. But it was not annexed. That was not annexed due to some mistake.
So file a supplementary affidavit instead of withdrawing this.
Sir, my lord, better I will file new application.
Why unnecessarily you will withdraw this, file another application? You better file.
Okay, I will file supplementary. Okay, no problem. Okay, no problem, my lord.
The petitioner seeks leave to file a supplementary affidavit. Full stop. How soon will you be able to file?
By Monday.
Your purpose will also be served. Let such supplementary affidavit be filed by August 17 as prayed for. List this matter on August 18.
Okay, my lord. Very good. Highly obliged.
Come back on August 18.
My lord.
Next is also my matter, my lord.
Yes, next also there is a mistake or it is all right?
No, there is no mistake.
Yes, you are not appearing in the next matter.
No, that is a separate bank.
839, I'm not appearing.
This is against PNB.
Affidavit of service. আগেরটাতে affidavit of service লিখে দিয়েছেন তো? আগেরটাতে লিখে দেবেন। Affidavit of service filed in court today is taken on record, লিখে দেবেন।
This is for essay application filed in 2022. Still pending SRAD while we have submitted the SRAD service proof.
লিখে নিন। Affidavit of service filed in court today is taken on record. None appears for the respondent bank despite service. Full stop, paragraph. আচ্ছা, despite service যেখানে লিখেছেন তার আগে লিখে দিন। The affidavit of service indicates that
by hand delivery, both party by hand delivery.
The respondent bank has been served a copy of the writ petition by hand on August 4, 2026. Full stop. Therefore, none appears for the respondent bank despite service. Full stop, paragraph. This writ petition seeks expeditious disposal of expeditious disposal of a
Essay.
SARFAESI application being essay number 473 of 2022 pending before the Debts Recovery Tribunal -3, Kolkata since May 2022. Full stop. Paragraph. What is the stage of the essay?
There is no hearing, still SRAD.
It is submitted by Mr. Pitti, learned advocate, appearing in person, learned advocate, Mr. Pitti appearing in person, that the matter is still languishing at the stage of service. Full stop. Paragraph. Since the SARFAESI application has been filed in the year 2022 and has been pending since then, this writ petition is disposed of by requesting the Debts Recovery Tribunal -3, Kolkata to dispose of the SARFAESI application being essay 473 of 2022 as expeditiously as possible and preferably within a period of 4 months from the next date fixed without granting any unnecessary adjournment to either of the parties. Full stop. WPA 18946 of 2026 stands disposed of, no costs.
My lord, there is only one. Please mention if bench 3 is not available, then charge available.
In case, the presiding officer of Debts Recovery Tribunal number 3 is not available, the petitioner will be at liberty to file appropriate application before the presiding officer holding charge of the Debts Recovery Tribunal number 3, which shall be considered by the said presiding officer in accordance with law.
Highly obliged. Thank you, my lord.
WPA 18946 of 2026 stands disposed.
Lordship, I am earlier, petitioner father was the consumer and paying electricity bill regularly for his commercial and industrial line. All of a sudden, that line has been disconnected by the CSC on the alleged ground of pilferage. Against that, I move a writ petition before this honorable court, that is annexure P2, page 13. Kindly see. Page 13, annexure P2.
Yes.
As per this order, my lord, fine, directed to pay 1 lakh rupees and reconnection charge and meter replacement charge. We paid, line has been restored. There is an order also to file affidavits. Both the affidavit filed by the petitioner as well as CESC authority. We have annexed that. And that time, the provisional assessment was 3,38,100. That is page 12.
Yes.
I paid as per order 1 lakh and meter charge and reconnection. After affidavit, the matter was not heard. And CSC has not demanded any amount from us. Thereafter, the matter finally come before this honorable court, that is annexure P5, page 39. In the meantime, petitioner father died. I annexed the death certificate. Page 39, annexure P5.
there is a dues of, as per this order, 1,53,335. Because it has not been filed in time, the substitution application, that is dismissed. But no merit, nothing has been held in this matter. The matter pending before this court. Thereafter, my demand is now 1,53,000. We challenge this matter by the petitioner's son, here Vishwajit Mondo, and challenge is that they believe that they have not created any pilferage in the state meter. That is their view. And that matter be hard because it cannot be hard because of delay filing of substitution application by petitioner, now petitioner father. Now, moreover, finally, after filing this, they are now entitled to get 1,53,395 as per last order. And you will kindly see, they have sent a bill now without any explanation. The amount of rupees 45,69,482. Kindly see. If entire plant and machinery and his house, land, everything sold of the petitioner, that amount will not reach.
He is the industrialist.
Oh, জল তৈরি করে বোতলের জল industrialist. How they have arrived this amount? I could have said to my client, you pay that amount, which is, but for 45 lakhs, how they have calculated, no basis, nothing has been declared in that. Not. So arbitrary, malafide, I don't understand. I think let them file an affidavit on that context. But that amount cannot be arrived at.
But then this
1,29,000, I can insist my client pay it off, dispose of it. That is different.
But they are entitled to interest. It was way back.
There is no such order.
It was in 2000. The order says excluding interest.
There will be
by which the
there will be no. Usually, what is happening in the
order by which the writ petition was dismissed, 2005
Yes.
writ petition.
Yes,
That says
because of not filing.
Yes, but the coordinate bench cannot get over this order. If you can challenge this order, get it set aside, that is a different thing. But one coordinate bench cannot set aside another coordinate bench's order. This order.
No, I am not saying about the set aside.
Yes, then.
But what I am paying.
If the principal sum of rupees 153,395, which was due in 2005.
Yes.
For 21.
Usually, what is my lord is filing? Usually, that amount we
Why
pay.
don't you challenge this bill before the GRO?
GRO.
Grievance redressal officer. Yes, because it again becomes a billing dispute, or sort of.
If my lord direction, I can.
Final order was passed in 2004.
Yes, that is.
Meter is still running in the name of his father. Father died in the year 2013. No substitution application. No steps has been taken for change of name. All of a sudden, this matter has been taken up. The court has taken serious view on that issue. The meter is in live conditions. They are running and enjoying the electricity.
And we are paying every 5 months electricity.
And there is a pilferage on that issue. No appeal has been preferred against that order. And your lordship knows, under section 127, your lordship knows very well that if it is not paid, there is an interest component is there.
Very well. If he is aggrieved by this interest component.
Yes, let them challenge.
Decide. The GRO only will have to decide, because it ultimately boils down to what? Boils down to a billing dispute, or GRO will not have jurisdiction. What is the regulation?
So far the billing is concerned. GRO, it's a case of a pilferage.
No, this is not the case.
So the GRO
it is no longer only a case of pilferage, because on the amount which was finally assessed, you are now charging interest. Now, to what extent your charging of interest is correct or incorrect, who will decide this?
I understand.
Because if the
But then we'll furnish the entire details to them.
very well, you will furnish the details. Suppose he is aggrieved by the detail also. Who will decide that? Writ court cannot decide that. Who will decide? There has to be an authority who will.
There is a calculation in the regulation.
আরে সেটা তো বলা আছে।
That I understand, Mr.
সেটা
Kole.
বুঝেছি।
If I am aggrieved by the calculation, who will decide that? I can challenge the calculation also, because
I think there is a calculation what would be the charge.
even then the calculation is there in final order of assessment also. But we challenge the final order of assessment because there is an appellate forum. Now for this there is no forum. So therefore, will the writ court decide the dispute or somebody else has to decide?
So far the concern is the interest components concern, subject to kind approval of your lordship.
Declared in the bill. That is not stated in anything in the bill.
The order, it has been specified excluding interest. If your lordship kindly say, and this order attend finally. Now, subject to kind approval, your lordship. May I suggest one thing? So far the amount is concerned, that is 1 lakh something. That has to be paid by him. Let him pay that amount. And so far the interest components is concerned, your lordship under regulation 56. GRO has got the.
What is the name of the regulation? It is not regulation 50, it is notification 56.
Notification 56, West Bengal Regulatory Commission. May I?
Redressal of grievance of consumers.
May I say, so far the yes. I think 6 will be there, clause 6. Subject to correction, may I place it?
95.
আরে হ্যাঁ জানি আমি। Lordship got that regulation notification 56?
Yes, I have got it.
Yes. Mas 6, clause 6 means regulation 6, lordship. Only precondition that amount is to be paid subject to lordship kind approval. Lordship kindly get that, and thereafter he may.
Mr. Haldar, Mr. Sahara is right in that. So far as 1,53,000 is concerned, you pay that. So far as the balance is concerned, you have a dispute whether that is payable or not. That can be referred to the GRO.
Until then, there will be no disconnection.
Yes.
Naturally.
That will be decided by the GRO, because how much interest is payable, how will the calculation be done? It should be first done by the fact-finding authority. It will go to the ombudsman, then the High Court. At the threshold, if High Court starts doing, then
No, I am not.
You will go to the division bench with this and the Supreme Court. The authorities on the ground level will have nothing. That can't be the idea of the statute, because we have to. So
that's why I put it suggestion
GRO will not have jurisdiction to assess an amount. That is right, because that is for the assessing officer. Once it is assessed, what amount of interest you are claiming on the account, that again becomes a dispute which is.
I have no doubt. I have no
GRO, because that is not to be done by the assessing officer. The calculation of interest will not be the assessing officer's domain. It is not within 126. The formula may be there, but whether the formula has been rightly applied or wrongly applied, who will decide that? It is a complaint within the meaning of section.
Ready to.
Because this interest has been charged under subsection 5 of section 127. And
Very
so far
well.
the component
But
is,
whether-
that's why I'm saying.
Under 127, suppose interest is wrongly charged.
Yes,
Then
yes.
is there any provision for appeal against that? Under 127, appeal is only against final order of
Final
assessment.
orders.
Against charging.
I appreciate.
Yes,
I
there is no
understand.
appeal.
That's why I
There
put
is no
suggestion.
provision anywhere else. So GRO has
Yes,
to
that's why I'm saying. That's why I'm saying notification 56 will
because
come in.
otherwise it will become unworkable. Every small dispute with regard to interest calculation, writ petition will lie.
But every
can't-
day there is a writ petition on a very.
That is different, but that can't be done because then this we will be making nonsense of this
Yes,
regulation.
yes. That's why I'm just I say just subject to approval of your lordship. But this amount is to be paid within certain period, lordship.
Yes.
My lord, item number 41, I am behalf of the petitioner.
41.
41.
Malam for the WBC.
In this case, my lord, the electric pole leaning towards my gate, and it is create a lot of hindrance. And for this purpose, I have filed this writ petition. After that, earlier bench passed an order to possibly solve to the issue, and they have arrange a settlement. I have proposed that if this electric pole shifted 3 feet away from this place, it will be everything is solved, but sort out. But they have raised objection that if there is in a new place, there is another side is a big water body, is a pond like that, but it is not create any hindrance. But the owner of the pond create objection to show that. But on the between the electric pole and pond side, there is a wall.
Mr. Bandyopadhyay, why don't you approach the DM?
Kindly pass on this.
Approach the DM for finding out a
The
way.
initial allegation was that, my lord, the pole has been installed in his plot. That is not the fact.
No.
Then he, my lord, raised the allegation that the pole is leaning towards his gate. He is being obstructed for ingress and egress, and it is dangerous for the usage of that property. It is not. We have made twice inspection reports have been filed. It's not leaning towards its gate.
One minute. The pole is not on your property.
No, pole is not. It is a roadside.
Then it is leaning on your property.
Leaning over towards my gate.
What is the on your building gate?
Building gate, premises gate, and it is a.
He runs a maze there.
Photograph also is there.
Plot runs a maze there. A big gate is there. It is not leaning towards his gate. It is leaning. It was leaning towards the road. And we have repaired it because at the time of construction of the boundary wall, the stay set was cut by some unknown persons. That's why the pole leaned towards the road. I have stated in my joint inspection report. He was present. Now he showed up.
Pole is leaning away from the building gate.
My lord.
Yes.
Leaning away from the building gate, not on your building.
And it's
it is a photographer saying that it is towards this gate.
I have also.
Yes.
Shows that it is away from.
No. It is from that, but it is towards the gate side, not our linear premises side, but it is towards the gate side.
Yes,
It is not a roadside.
your gate, but it is not leaning on your gate. It is leaning opposite to your gate.
No, this gate is mine.
This yellow gate is yours.
Yes, mine.
So it is away from the yellow gate. It is leaning this way. Your building is here.
No, but this building is inside. That is, it is not leaning towards.
Necessarily worried.
It is not. It is creating hindrance to ingress egress of my.
Your lordship will find another pole is there. That is a high tension line pole.
If you want removal of this, then in that case they will have to approach the district magistrate. And it is not on your property. So how can you object?
But it is leaning towards our gate. That's why we are sitting.
Towards your gate. The photograph does not show you. Photograph shows it is leaning against your gate, not on your gate.
My lord, it is physically it is also showing that it is leaning towards a gate.
How is it physically showing that?
That is showing.
Photograph is not showing that. How is it showing? Show me. Show me, take this photograph and show me how it is towards your gate. Your gate is behind that, it is leaning in front of it. Show me. Show me how it is in front. It is leaning away from your building.
This gate is ours. And it is
the gate is behind that, it is leaning towards
not roadside. It is not
leaning on your gate. That is clear from the picture. You see,
but I'm saying, but you can take that. I'm saying that it is leaning towards a gate. It is my submission, and it is the photograph also. That is, it is not. If it is
your submission is contrary to the evidence that you are producing, so your submission alone will not do. What you are producing in support of your submission is not supporting your submission,
because it is create hindrance to ingress egress of a car and everything towards my premises.
District magistrate, if he feels he will,
I have
there is
stated
no
in my report,
order
my
can be passed.
there is no alternative place. He could not show any place.
And in
my
any
lord,
case, if it is not your road, how hindrance will be? Your road is left, your building gate is left. It is not in front of your gate. It is neither in front of your gate, nor is it obstructing. It doesn't appear that it is obstructing. Unnecessary case.
My case is this, that leaning towards my gate, and for that reason, it is a vehicle and everything else is it is obstructing to ingress and egress.
You provide a suitable location on your own plot, if you feel so.
He could not.
They will be
He
able
showed
to
a place which
otherwise,
belonged to.
There cannot be a mandatory direction.
No. Then, if it is possible that there should be an underline, that will be also the petitioner will provide the cost for that one.
On the last occasion, Lordship directed me to bring the instructions from the bank, my lord. I have but I've given the Lok Adalat's order and the instructions placed to me. The petition has become infructuous, my lord. Because
You are appearing for the petitioner?
No, my lord, I'm for the respondent bank, my lord.
Who is appearing for the petitioner?
On last occasion, my lord, I submitted, so they must be in impression that it is no more. It's my duty to inform your lordship that it has been withdrawn. So the grievances have already been settled. They were actually the purchaser of the property of the borrower. We have settled with the borrower. Now it is between the borrower and them. We are not going to take any surface action. That is clear from this.
You have not taken any action.
No, we will not take because the matter has already been settled, and the account is closed.
Anyways, they are not appearing. I am dismissing it for default.
Lordship,
record your submission. Record your submission. None appears for the petitioner. Full stop. No accommodation is prayed for. Learned advocate appearing for the bank.
Respondent number 1 and 2.
Respondent numbers 1 and 2. Hands up to court a copy of the letter dated
I am for the petitioner.
I appear
Lordship, on the last occasion, Lordship directed the petitioner to serve afresh upon the private respondents. Lordship, I have served, but both the endorsement has been returned with no such persons in the address. Lordship, this may
what new supply?
New connection, Lordship.
Yes,
Now,
Mr.
Lordship,
Mukherjee, you are wanting to give or you don't want
Lordship, may I submit, Lordship? Primarily, the petitioner applied for the domestic connection. The CSC authority rejected the application on the ground of splitting of load. I have annexed the letter of the CSC authority, Lordship. It is in the page 11 of the writ petition. Now, Lordship, kindly sees their report which they have filed, report form of affidavit, report in form of
paragraph B.
page 5.
Paragraph B.
Lordship, they have
that split load thing, na?
They have stated that I am getting connection from the persons who are objecting my connection. Lordship, Lordship, may I submit? Lordship, for splitting of load, there has to be some nexus between both the parties. Lordship, I have no connection with Swaroj Singh and I mean,
Splitting of load, my lord, if we can prove that he is getting supply, that is sufficient. And according to our inspection, my lord, he is getting supply from the meter of one
Swaroj Singh, because these are all factual disputes.
Please,
Lordship.
WBSCTC.
This matter, I along with Mr. Prantik Gorai for the petitioner.
My
He's
lord, I
on
am appearing for the petitioner, my lord. My lord, this matter, my lord, as per the lordship last direction, we have already served upon the state response, upon the government leader's office, my lord. My junior is there with the advocate on the with the affidavit of service, my lord.
For the state.
My lord, the matter is, my lord, the matter pertains to a scheme. My lord, the matter pertains to a scheme under the West Bengal Tourism, Government of West Bengal Tourism Department, my lord. Under that, an eligible unit was entitled to an electricity subsidy. I was an eligible for a period of 5 years from the date of commencement. But I am eligible. I am eligible under the scheme, my lord. Eligibility certificate has been issued. I'll show the documents, my lord.
It has become new act has come into operation.
My lord, I am talking about. I am placing it for a period when it was operational, my lord. This circular was operational. My lord,
Mr. Gorai, are you unwell?
My lord, yes, my lord. I am hospitalized.
What is so urgent that you have to do it from the hospital?
Well, I just wanted to complete a very matter well spending for a long time, my lord.
Very well.
My lord, I will only be praying, my lord.
If you want any time to be fixed, I can fix it according to your convenience, not a problem. Subject to what you say. If you want to do it now, I don't have any problem.
My lord, I was humbly seeking only a very short prayer I was seeking today. My lord, at this point, my lord, I have already written a letter, several letters, last of which is of 4th of March 2025, my notice, which is page 59. Let that be considered by the Principal Secretary, Government of West Bengal, my lord.
Consider and dispose of
My
that.
humble submission, the scheme under which my Lord and Friends client has applied for subsidy that does not exist. It has been, a new act has come into operation.
He has made a representation, say that and dispose that off.
As your lordship. If he show, which is not subject to approval, your lordship.
Page 59, my lord.
59.
Yes, my lord.
The key দিয়েছেন the Oracle Guest House.
Yes, my lord.
Yes.
59 I don't have. The writ petition ends at page 45.
No.
The 59 is there.
59 is there.
No. দেখুন দিন তো নাকি
না না ওটা তো আগে থেকে হয়েছে
Kindly have might. May I do it this way, my lord? I place a fresh representation. Let them consider it, my lord, on merits.
That is the one, but new act has come into operations, which was notified on, my lord, 2nd April 2025.
My lord, I am much prior to that. This is of 2013.
Oh, pagination is wrong. Oh, that is why.
Instead of 59, it should be on 43.
Not properly pagination.
No.
Which is why I said my writ petition ends at 43, 45.
I apologize on behalf of my juniors, my lord.
Page 43.
43.
Page 43 in this writ petition is 59 in is yours. In yours.
Lordship.
It's a communication dated 4th of March 2020.
Is concerned, we have no role.
He just wants consideration of this representation. Nothing. The writ petitioner is aggrieved by the non-consideration of the petitioner's representation dated March 4, 2025, addressed to the Principal Secretary, Department of Tourism, Government of West Bengal. Full stop. Paragraph. It is the petitioner's contention that the petitioner is entitled to refund of certain sum that had been paid by the petitioner on account of electricity duty during the period 2012 to 2017. Full stop. According to the petitioner is entitled to the refund of said sum in terms of
in terms of the West Bengal Incentive Scheme 2004.
In terms of the West Bengal Incentive Scheme, 2008. Full stop.
2004, my lord.
2004. Within bracket WBIS apostrophe 08. Yes, 2008.
I apologize.
Full stop. Paragraph. Learned senior advocate appearing for the respondent state authorities submits that the scheme is no longer in existence. The same had been scraped off in
by an Act 4 of 2025, notified on 2nd April 2025.
by Act 4 of 2025, notified on 2nd April 2025. Full stop. Paragraph. Having heard learned advocates appearing for the petitioner, appearing for the respective parties, and having considered the material on record,
2nd April 25.
this court does not find any reason to keep this writ petition pending. Full stop. Since a representation has been addressed to the Principal Secretary, Department of Tourism, the Principal Secretary is directed to consider and dispose of the said representation, which forms annexure P8 at page 43 to 45 of the writ petition.
May it be Lordship pleasure to mention the date of the communication, my lord, because there is some might be
I've
some.
said so. I've said so.
Yes, 4th of March 2025.
March 4, 2025.
By respondent number 1.
By respondent number 1.
He is the author.
By the Principal Secretary, Department of Tourism, i.e. the
Respondent number 1.
The respondent number 1, as expeditiously as possible and preferably within a period of 8 weeks from the date of communication of this order, strictly in accordance with law. Full stop. It is made clear, that the accordance with law, by passing a reasoned order. Such reasoned order shall be communicated to the petitioner within a week from passing thereof. Full stop. Paragraph. It is made clear that the reasoned order passed on the petitioner's representation would not enliven any dead right or would not be used to get over any bar of limitation that may have surfaced during pendency of the present application. Full stop. Paragraph. It is further made clear that this court has not gone into the merits of the petitioner's claim, and all points are left open to be decided by the respondent number 1 in accordance with law. Full stop. Since affidavits have not been invited, all the allegations made in the writ petition shall be deemed not to have been admitted by the respondents.
WPS may I pay one thing? May I pay one thing, my lord? Right of audience before the Principal Secretary, my lord.
That will be difficult. Before the
My lord,
Principal Secretary,
one day, my lord,
he is a busy authority. Let him dispose of. If you feel that you have a point, but I have indicated that it will not be a case to override a bar of limitation. I have said only period of not during pendency of the writ petition. That may have a reason. That may have a reason.
Lordship will kindly give me a right of audience, my lord. My lord, a right of audience, because I have to place my.
No.
Well, kindly, my lord, kindly consider this aspect.
No. That will be turning them into a hearing authority that they are not.
One day hearing, my lord, it's a very, very short, my lord. I'll show those, at least I'll be able to place those documents, my
Very
lord.
Well. Upon affording an opportunity of hearing to the petitioner.
Yes.
Obliged, my lord.
Much obliged.
Normally all cases they call for hearing and given it.
And if there is a bar of limitation in the meantime of 2008 scheme, then this representation will not enliven that. I have made that clear.
I know that. I have heard that.
I will indicate there is a judgment of the court. I am not forgetting. I will indicate that in the order. I am keeping you on notice.
Just right to cut the limitation by making representation.
Yes, that I will indicate. I will indicate the judgment also. Yes, next.
45, I am for the respondent number 10 and 11, my lord.
I am for the
Get well soon. Yes.
I am the private respondent number 10 and 11, my lord. our private respondent filed an application for new connection for submission pond in the year of 2024, Mala. Petitioner has filed an objection before the concerned authority, and thereafter he filed the writ application. Private respondent suffered day after day, my lord. He has not.
You have not given broad connection.
Lordship, as per my instruction, this is year instruction of the year 2025, Lordship. And thing is, Lordship, this is a safe zone, Lordship. The plea that is taken in the writ petition, Lordship, is that it is a critical zone. Pandua is a critical zone. Earlier, it was a critical zone, Lordship. However,
None appears for the petitioner. No accommodation is prayed for.
No.
on last occasion, Lordship, they also.
Oh, yes. Last occasion,
I think, Lordship, there was no one for the petition. I think.
No, there is no order.
Lordship.
Lord, in 46, Lord, I appear on behalf of the petitioner. Lord, the petition relates to, Lord, where the auction purchaser is seeking, Lord, refund of the earnest money which has been paid pursuant to a sale in surfacing. Lord, I'm otherwise ready, Lord, to proceed, Lord, but Lord, my learned advocate on record informs me that the affidavit of service could not be, Lord, filed. Lord, if your lordship can keep it, Lord, tomorrow, if your lordship kindly, Lord, otherwise I'm ready, Lord. I have
not a problem.
Lord, very small point, Lord, I'll indicate, Lord, no access road which was provided. Lord, sale is on as is where is basis. However, my lord, there was never any access road which was provided to the petitioner. Lord,
but at the time of inspection, you did not see this.
My lord, at the time of inspection, Lord, inspection takes place after I have put in the 25% amount. Lord, this is again a question which lordship will have to test this, Lord, because Lord, I have come across Lord decisions wherein Lord reference has been made to Rule 8.7 of the rules, Lord, security interest rules, Lord, wherein Lord courts have interpreted it to say that Lord the bank is under a statutory obligation to disclose whether there is a service road or not, Lord, because the difficulty arises where the petitioner, my lord, has now to access some other person's land in order to access the property in question. Lord, I am armed with
and when did you make the first representation after
Lord,
taking inspection?
I'll tell your lordship, my lord, very briefly. My lord, e-auction held on 21st, on 13th, my lord, e-auction notice published on 21st February 2024. My lord, my bid is accepted on 13th March 2024. My lord, thereafter, my lord, I make the payment. My lord,
no, but before the acceptance of the bid, you are entitled to inspect the property. Who said that?
My lord, that is something which possibly, my lord, my client did not do. My lord,
then you accepted this.
Ought to have, my lord, not done. My lord, however, my lord, lordship will kindly see this, my lord, and whether or
then
not.
why did you not approach the DRT? Your remedy is there before the DRT. There are judgments to that effect.
Yes, my lord, I appreciate. My lord, this has happened after, my lord, I had participated. Thereafter, the bank has.
You should not have participated because before participation, you should
have inspected, my lord. I ought to have inspected.
Then how do you hold them guilty?
Lord, on that, Lord, I'll only show, Lord, two decisions of, Lord, one of the Orissa High Court and of our High Court, wherein it says that wherein there is a public access road is not provided for either in the, Lord, notice. Lord,
but was the case was that case one where inspection was not allowed or inspection was not taken?
Lord, over here, Lord, there was no, Lord, question of there being any inspection taken. We were not invited. Lord,
You're not supposed to. You should have gone there.
Yes,
you should
Lord,
have
there is
said
no
there.
doubt about the fact, and
sale notice itself says
yes.
it must show that inspection can be done on such and such date.
Yes,
Sale
Lord,
notice must
Lord, that is
indicate
not there. Lord, that inspection, Lord, only if your lordship kindly comes to the notice, Lord, page 19 at the bottom. The lordship will find page 19 at the bottom. Lord, for details, lordship has it.
Yes.
Right at the end, for details, terms and conditions, please refer to the link provided in such and such,
yes,
or auction so and so. Lord, this is the limited, Lord, invitation that my client.
Where is the detail? Where are the details? The details.
Lord, those details, Lord, were in the portal. My client ought to have checked up. Lord, I am not shying away from that fact at all. Lord, that is something which my client ought to have done. Lord, it was not done. Payment was made. After payment was made, Lord, we come to know, then my client becomes wiser. He goes and he finds out that there is no public access.
This becomes difficult.
Lord,
This
I
is not
appreciate,
how you do it.
Lord, and that is why Lordship will test this on, my Lord, Rule 8.7 of the SARFAESI rules, whether, my Lord, that.
Then why don't you approach the DRT? You should have approached the DRT. Why High Court?
Lord, approaching the DRT, my Lord, there is always the remedy is always available to me to come before your Lordship. Lord, that remedy is always there available. Lord, no, notwithstanding the fact, my Lord, I ought to have gone. Lord, I've come before your Lordship and I'm seeking.
Your remedy was before the DRT only. You could have gone there after having the participation was done in when? In 2024.
Lord, I had participated. Lordship will find, my Lord.
And you have come here
on
after
12th
1
March
year.
2024.
And you have come here after 1 year.
Lord, because I was communicating with the bank.
That
Lord,
is
bank,
neither here nor there.
Lord, I'll tell you, Lordship, Lord, forfeiture was
difficult.
Lord, your Lordship will consider. Lord, let me serve them and come back. Lord, your Lordship will consider this.
The petitioner shall serve a notice along with a copy.
For the petitioner and
Not today.
and not not this week, my lord.
Not this.
That 43.
Not this. Next.
48, 40.
No, I am for the petitioner. Can you see the last order? 10th July, 10th June 2025.
Yes, Mr. Mukherjee.
Yes, man.
A petitioner made an application for new connection. Quotation money has been paid. But till that connection has not been
Why are you
given.
not giving him connection?
We have filed a report, my lord. My lord, we kindly see.
File করেছেন নাকি?
Where you have not filed any report.
Lord, we kindly peruse your lordship's order dated 20. Huh?
What? There is no order of mine. There is an order dated 10 June 2025, and as the track record shows, 10 June 2025 orders. You have. It's a 10 June order, so all 10 June orders from morning since evening you have not yet complied. There is no single 10 June order that you have complied. What is so special with this?
Kindly give me a
10 June is what?
10 June.
Every order of 10th June, I have seen that you don't comply.
I have. May I file the report? 101092.
There was a direction to file affidavit 10 June.
Direction to affidavit again. Affidavit in response to the allegation made in the meantime, CSC should conduct inspection with the help of local police at the cost of the petition.
File its affidavit in response to the allegation made in the writ petition.
We have prepared a report, man. Should I put it in the way of a report in the form of affidavit?
That was for affidavit. You are willing to give him supply or not?
There is an objection, man. We are ready. Kindly come to the last paragraph of the report, man.
Who is objecting? There is no private respondent.
No private respondent. Objection made by the
other two buildings, my lord. May it's better I put it in the affidavit, madam. Only give me a week, I'll put it. I will annex this report also.
Mr. Mukherjee, learned advocate appearing for the CSC Limited, seeks further time to file report in terms of the order dated June 10, 2025. Let such affidavit be filed by August 17, 2026.
T9 Lordship, I am playing for 1 week's time. There was a direction to file exception to the report. Lordship, client was not in
This week, not this week. Next.
একটা অর্ডার হতো তো
Private में. Lordship, I am for the petitioner, Lordship.
Lord, I am
Application, Lordship, there is a direction to upon the authorities to file a report, your Lordship. Report fine. Hey, we didn't process. Lordship, in this matter, Lordship, I am just praying.
Lord, I am
for
filing the report. Your Lordship kindly let it.
I am just praying for a shifting of the existing line that is existing over my property of the line belongs to the private respondents. I am just praying for shifting of the line because there is a pathway available and poles are also available nearby the house of the private respondents. This is my simple prayer. Existing line over my property.
What is your report, Mr. Kole?
Well, we are trying to, my lord, solve the problem, but there is a civil suit injunction is there against the private respondents not to create any obstructions. But the private respondents are creating obstructions. So far, the, my lord, reallocation and reroute this problem. That's saying that civil suit is pending. So,
what is the order of the civil court?
Lordship, the private, just only for the just
no,
I have the copy.
Detail order should be.
It is there. It is there. Just now I received. Lordship, I tender apology. It's there. Madam.
দেখি দিদি ওটা দিন
Permanent injunction to disposal upon the defendants. Defendants are the private respondents here.
There is a decree, not only order. There is a decree of injunction.
That, my lord, I am not successful.
At the time
of we are not the party to that proceedings.
Because
it is not against them.
Yes, naturally.
This is against the private respondent here.
Yes, your lordship.
Abani Kormakar.
Yes. Private respondent is there.
Number 5.
He is creating obstruction.
Both, my lord.
Both means who else?
Private respondent 5 and 6.
They are also parties here.
Yes, your lordship. And regarding the pendency, I have stated in my petition at the time.
Only trimming of trees is required, nothing else.
This injunction.
So it's not pending. It's decreed. How is it pending?
Now it is decreed. At the time of filing, it was pending. I have stated that.
This was decreed when? 29 November 2024.
That we do not know.
I give a copy of this.
Lordship, just give me. I'll just print it.
You are otherwise agreeable to.
Well, that is the report. Will not say trimming of trees is required. Otherwise, free access is there because there is no obstructions created by the petitioners as per instructions. But even then, we are try to clear the passage and pathway. We have no difficulty.
What do you want?
I just want this shifting of the line. They kindly turns your
shifting of whose line?
Private respondent.
Line of the private respondents passes through my property in such a way that the house of the petitioner has roof. And in such a way, your lordship, it is touching my house, and if this isn't at any point of time, mishap can occur.
And the line will be shifted where?
There is a pathway between the highway in front of the house of the private respondent, and pole is existing. Pole is also there.
That is possible, Mr. Kole.
Well, exactly, Miller. Relocation is possible or not, Miller. That's highlight.
What does the report say?
Report I have stated that we are trying to.
Page number 19, lordship.
Report says, Miller, that we are agreeable to do so.
No, but pathway, whether where
yes, pathway is there or not, Miller, that was not clearly indicated.
You have not.
The connection existing along with the same pathway since very long. That was, Miller, stated. And no unsafe condition endangering the life has been reported to have been occurred till date.
Already, your lordship, once a fire incident mishap took place.
No, joint
of that line over my property, over my house. Page number 19, your lordship.
Report Initially, they have given no objection.
You don't want the branches to be trimmed.
Yes.
You don't want the branches to be
No,
trimmed.
I just want the shifting of the line. They went there, they told that we cannot shift, we are just trimming the branches. For the trimming of the branches, I have not come before this court. Because trimming of the branches, I can do myself. But the unless and until the lines have been shifted, your lordship, the problem remains.
Your lordship, kindly consider the report last page. Their grandmother, initially, my lord, they have given no objection. It's a Bengali.
For trimming of the branches. He wants shifting.
No, my lord, initially for effecting connection, they have given no objection. In Bengali later, your lordship, I got it. The last page.
My grandmother died a long back.
No, that is different. I'm not saying.
2020, I became the owner.
Is this of 1996?
Yes. No. Initially, 1996 connection was effected, not now. It's not new connection.
And connection to your property only.
My property is in the middle. The connection is going from one portion to that portion. The private respondents are both sides. It's just passing my property.
And only one pathway.
And it turns to page number 19.
So it cannot go through the pathway.
Well, he can.
The connection cannot go through the pathway.
No, because your lordships kindly see, only one angle is fixed and they have agreed to effect connection that we have done. Now, after a long time, they may not file this writ petition trying to change or shifting this connection. In Bengali, it has been written in পরবর্তীকালে পৌরপিতা মহাশয় ও স্থানীয় কাউন্সিলর ও স্থানীয় বাসিন্দাগণের উপস্থিতিতে আলোচনান্তে সিদ্ধান্ত রইলাম যে বর্তমানে
notice on the private respondent, see what can be done, because the notice is 1 year old.
There's existing poles and the pathway.
Very well. The notice is 1 year old. You serve one more notice. Let us see. Report in the form of affidavit filed on behalf.
I am for the petition, Lordship. Lordship, petitioner has applied for a connection of submersible pump. Compliance have been done. Lordship, thereafter no steps were taken to give the connection. Thereafter the writ petition was filed and the WBSEDCL authorities submitted that there is an objection of the villagers, some of the villagers. That's why the connection could not be given. Lordship, kindly sees 2 orders have been passed in this writ petition. Primarily, we have suggested that there is an alternative route by which the connection can be effected, and in that route there will be no objection. Lordship,
2 orders.
Lordship,
Where are the 2 orders?
Lordship, in this writ petition, passed by Justice Kaushik Chandra, Lordship.
Oh, earlier.
Yes. And Lordship, by the first order, the joint inspection has been conducted, and they have also submitted the report before the court, Lordship. What has happened, Lordship, on the day of inspection, it was not informed to the petitioner earlier. That is why petitioner was not present.
No, it's
And now, thereafter,
everybody was notified, but petitioner was absent.
yes, petitioner was absent. I am admitting, Lordship. Now, Lordship, I am praying that another inspection be carried out. Petitioner will be present, Lordship, and there is a alternative route, and the matter can be sorted out, Lordship.
Why not? What is again and again? We will add that on behalf of the petitioner.
Since Mr. Haldar wants you to go once again, go.
I do not know, because again all persons.
Take him also. Take him.
Because that's a sheer harassment to us. Grateful, Lordship. Hey.